The Senate Judiciary Committee will come to order. The clerk will call the roll.
A quorum is present, Mr. Chairman.
We got it. We have a quorum? We have a quorum? Okay, we have a quorum. If you want to leave your proxies, you can. We have there are two, let's see. One person, Delegate Levine, asked for his bill to be reconsidered. It was killed on Monday. There's a motion to reconsider Delegate Levine's bill, so he's got a substitute for it.
Mr. Chairman. Mr. Chairman.
Yes, yeah. Senator Sasslaw moves to reconsider Delegate Levine. Yes, it was. The prevailing side is the side that killed it. Okay. Okay. Senator Sasslaw moves to reconsider Delegate Levine's bill, which is, what's the number of that bill?
1948.
Okay. I second the motion. All in favor of reconsidering the bill, vote aye. Opposed, no. Okay. Okay, fine, thank you. So that'll be reconsidered at the appropriate time. Should we do the Civil Law Subcommittee report first? Is that okay? All right, Senator Peterson got 5 bills in the Civil Law Subcommittee that just met yesterday. Senator Peterson, Civil Law Subcommittee.
Thank you, Mr. Chair. And I'm going to take these in order with House Bill 2055. And we did have extensive discussion on all of these bills and witnesses, and I'll do my best to summarize them and then give the vote and then make a motion. The first bill was House Bill 2055. This had to do with child support obligations, and when a party's incarceration was deemed voluntary unemployment or underemployment, this would basically add language to the code that if you are incarcerated, that it is not voluntary unemployment such or underemployment such that income would be imputed to you. The Family Law Coalition did not like this, so we went back and forth. I think for those of us, and I did vote in favor, the issue is these are just criteria that a judge is going to consider. There's no hard and fast rule. The opposing viewpoint was this is a right to child support that's enjoyed by women and children, or specifically children, not to make any assumptions. And so, and therefore, you're divesting them of a right, and sometimes the situation may not dictate that. So again, we had considerable discussion on it. I know Senator Serville had an amendment, which I don't think we adopted.
Mr. Chairman.
We did not. So let me make the motion. We voted 5-1 to report the bill without an amendment, and I so move.
Mr. Chairman,
Mr.
we
Chair-
had two amendments.
you're right.
We adopted the alone amendments, but not the longer one.
Let me draw that back. We had one line amendment, which was adding the word, was it sole?
Alone, Mr. Chairman, in
Alone.
2 places.
We added the word alone in 2 places that had to do, I think, after incarceration.
That's correct, Mr. Chairman.
So I would move that amendment. Okay.
It's been moved and seconded that the line amendment be adopted. Is that all? Just one amendment? Go ahead.
Yep. Can we get a vote on that, Mr.
Okay, all
Chair?
in favor of the line amendment, vote aye, say aye.
Aye.
All opposed, no. Motion
Okay.
carries.
So that gets us in the posture we need to be in. We did not adopt Senator Servile's second amendment, which I assume he's going to get to, and we did vote 5-1 to report the bill, otherwise as is, and I so move.
Okay, it's been moved and seconded that the bill as amended be reported. All in favor of the...
Mr.
Go ahead,
Chairman.
Go ahead, Senator Serville.
Mr. Chairman, I had a different amendment I was going to offer today, but in light of the fact that we have 38 bills in our docket, and I think people want to get out of here, I think I'll try to make that amendment on the floor instead of doing it in committee. But
Okay.
this bill has some real problems with it, which I'll describe later. But anyway, I just wanted to warn everybody.
Okay, duly warned. Okay, the motion has been made and duly seconded that the bill with one amendment be reported. That's House Bill 2055. All in favor vote aye. All opposed vote no.
Ayes 7, no 6.
7-6, the bill overwhelmingly is reported.
Okay.
Okay, yeah, Senator Obenshain. Yeah, go ahead. Yeah, go Stanley's vote. Okay, it's really, okay.
Ayes 8, no 6.
Ayes 8, no 6.
Okay.
The bill is reported. All right, Senator Peterson.
Thank you, Mr. Chair. All right, next bill is House Bill 2099, Delegate Coiner. This was a bill on enforcement of judgments. Right now, the law has been for years, I think since the 1940s, that you have 20 years to enforce a civil judgment in Virginia. This bill would change that from 20 years to 10 years. And the basis for that change was that these judgments are on the books indefinitely, and when you go to either purchase a house or refinance, oftentimes it's very difficult for closing attorneys to get the liens off the land. I think everybody appreciated that. The biggest issue had to do with retroactivity. If we're going to go backwards, what about people that have had judgments that are between that 11 to 20 year range? How are their rights protected? And we voted as a committee, and I can't remember exactly, but we moved to amend to basically remove the retroactivity. And I think we'll need to distribute a substitute on that. Is that correct?
Mr. Chairman, there is a substitute posted online that does exactly what you stated to remove the retroactivity portion.
Then I would move the substitute.
Is there a second? All in favor of the substitute, vote aye. Say aye.
Aye.
All opposed, no. Well, all right, vote then. I can't tell. All in favor of the substitute, vote aye. All opposed, vote no. On the board.
itself on our uncontested docket. So,
Okay.
Madam Chair, I would move Senate Bill 1182, Senate Bill 1184, and Senate Bill 1345.
It's 12 noes 3. The substitute is adopted. Is there a motion on the bill?
Okay, so with the substitute in front of us, I would move to report the bill.
Mr. Chairman, Finance asked for this morning, please.
Oh, okay. So it's been moved and seconded that the substitute be reported and re-referred to finance.
And just, can I announce, Mr. Chair, this will take effect as of January 1, 2022. So if you get a judgment after that, it's going to be for a 10-year period,
And
not 20.
Mr. Chair, I'd like to speak to that just a second.
Yeah, Senator.
I mean,
Deeds, go ahead.
For a long time, the law has been that you had 20 years to enforce your judgment. It was a lien for 20 years, and I've not heard a compelling reason today to change that law. Just because somebody introduces a bill and somebody's got a problem with a real estate closing, I mean, that's what you have lawyers for, to figure out how you get it solved, how you get the problem solved. I just don't see a compelling need for this bill. I think people's rights are going to be jeopardized, are going to be shortchanged, frankly.
Well, Mr. Chair, if I might,
Yeah, Senator Peterson.
and again, we took out the retroactivity, so nobody who has a judgment today is going to be impacted. The issue is, again, what is the appropriate amount of time for a judgment to be enforceable?
Mr. Chairman.
Mr. Chairman?
Senator
Anyways, that's
Obenchain.
it.
Senator
Yeah,
Obenchain.
and just to add to Senator Peterson's point, that the examples that were given and the explanation involved an awful lot of companies that come in and do business in Virginia from out of state for a short period of time, and by the time the property is changing hands, these companies are gone, can't be found. And the bill contains a provision for extending, so the rights of the lien holder can be protected so that they can enforce it beyond the 10 years. So I just would add that.
Mr. Chairman,
Yeah, Senator Murphy.
question for Senator Peterson. I understand that the rule has been for so long, 20 years. Is there an ability to reassert, and that's not the most artful word,
Yes.
the judgment after 10 years?
Yes, and thank you for asking that question. You can file a certificate which would extend 10 years, so it would be basically 10 plus 10. But if you don't file that certificate, you time out. So the short answer is yes, you can file a certificate to get another 10.
Follow-up question.
Yes, Senator Morrissey.
When you get a judgment against somebody and you put it down, let's say Senator Servo and I get into a fight. I'm not being cheeky. It's a legitimate question. I get a judgment against him for $5,000, and he's judgment-proof except for his house, and I put a judgment lien against his house. And I'm just going to let it sit there running interest. There's going to come a time where he wants to sell that house. And when he does it, he's going to have to pay me. Do I understand this bill? If I don't re-up after 10 years, let's say I've forgotten about it, that after the 10th year, sometime during the 11th or subsequent years, Senator Servo could sell his house and not have to pay me my judgment, which is $5,000 plus accrued interest.
Go ahead.
I'm not sure. I'm not sure I like that.
Senator Peterson.
Mr.
Go ahead, Senator Peterson.
I think that's correct.
Mr. Chairman.
All right, Senator Serval.
Yeah, Mr. Chairman, the existing rule is 20 years, and you can extend it by filing a motion with a judge and getting a judge to approve the motion. Under this bill, it becomes 10 years, and it can be extended by another 10 by simply filing a certificate with the court, so you don't have to file a motion to go in front of a judge anymore. You can just file the certificate, and it happens. But Senator Peterson is right. I mean, we were told that, a lot, and I think it was maybe Senator Obenchain said, a lot of companies vanish in a time period this long, and it's impossible to find somebody to actually sign the paper to release a judgment when it's been 12 or 13 or 15 years and it's out there. Another thing that Delegate Coyner pointed out to us in committee was that 20 years, I believe, is the longest in the United States. I think she might have said there weren't any other states that even had 20. I thought she said like the average was around 6 or 10 or something like that. So this sort of brings us more into line with the rest of the country. That was my recollection of the testimony.
Mr.
Any
Chair,
further discussion?
Mr.
Yes,
Chair,
Senator
would
Dees, go
would
ahead.
Senator Serval yield for a question?
Go ahead.
Right now, under the
yield.
law, it's 20 years, and you can re-up that 20 years. You can go for another 10 years after that, right?
Right.
So you're lopping 10 years off the judgment period, no matter
Yes.
what.
Yes.
Okay.
Mr. Chair?
Yeah, Senator Boysko.
Thank you. Someone brought me an example that, you know that this is not my field, but they were talking about examples from their clients. In 2002, a Petersburg woman's vehicle was repossessed. The lender obtained a default judgment for $2,300 in that year, in 2002. 18 years later, she is now having her wages garnished, and the balance that she owes now, $13,385 because of the interest. Yeah. And she's now being forced into bankruptcy. The original filing of paperwork with the court that rendered the default judgment was destroyed in 2012 after 10 years is required by law. And that was brought to me. I'm just sharing that information as a reason that I think that we should pass this bill.
I think the clerks do these things, but they shouldn't get rid of them so quickly. That's the clerk's problem.
Mr. Chairman.
Yeah, Senator Obenshain.
Serval.
Serval.
I believe the problem that Senator Boysko is describing, the reason that happened would be because the general district court destroys their records after 10 years. And if you take a judgment and you record it in land records, the judgment sits there in land records on the house, but the underlying paperwork from the case file in general district court gets destroyed after 10. And so that's, I think,
That's the problem.
what she's talking about, why that would happen. So there's that disconnect.
All right, we need to move it along. Okay, any further discussion? All right, they've been moved and seconded that the bill, House Bill 2099, as amended, be reported and re-referred to finance. All in favor of the motion, vote aye. All opposed, vote no.
Ayes 12, noes 3.
12 to 3, the bill is reported and re-referred. House Bill 2190, left switch, wrongful death beneficiaries.
Yes, and I have a substitute on this one also, Mr. Chair.
Yeah, Senator.
I would move
Peterson.
the substitute.
Okay, substitute. All in favor of the substitute, say aye.
Aye.
All opposed, no. Now explain what that's about.
Okay, this has to do with wrongful death beneficiaries. When there's a wrongful death case, you have classes of beneficiaries, and we changed the class, I guess last year, to add parents that were being supported by the decedent. And because we made that change, we had to make a change to subcategory 2 that basically is the next level of beneficiaries, which I believe is children of children, or I can't quite remember, but I think the bottom line is in subcommittee we came to agreement on the language and we passed it 6-0. It's basically just clarifying who receives the proceeds from a wrongful death case.
Okay, any questions? All right, Senator Peterson.
I move to report.
Moves to report the substitute of House Bill 2190. All in favor of the motion, vote aye. All opposed, no.
Ayes 15, noes 0.
15 to 0, the motion is carries and the substitute is reported. House Bill 2193, another delegate left switch bill.
Yes, House Bill 2193, believe it or not, was our most contentious bill, where a representative of the Supreme Court told me completely accurately that I didn't know what I was talking about, and she was actually probably correct. But having said that, this bill had to do with allowing settlement agreements and then essentially, rather than having the plaintiff non-suit the case, having a stay and then having the case basically stay within the breast of the court until the settlement is paid off. I think it's fair to say we were all, first of all, I have to move an amendment. Kristen, do you have an amendment?
Yes, Mr. Chairman, on line 14, after the word stayed, insert to a date certain, no longer than 12 months.
Right, okay. I would move that amendment.
Second, all in favor of the motion, the amendment, say aye.
Aye.
Aye. All opposed, no. Motion carries.
All right. Let me explain that amendment. What we wanted to do was basically have some time limits on this so you didn't have the case just staying within the court forever. So these settlement agreements have to be consummated within a year, which is actually more generous than in Fairfax County. I think it's typically 90 days. So that was, once we got through that amendment and worked that out, we passed the bill 6-0. And I would so move.
Okay. All in favor of the motion the bill as amended, all in favor of supporting the bill as amended, vote aye. All opposed, no.
Ayes 15, no zero.
Okay, 15-0, the bill is reported. All right, House Bill 2310, Guzman.
This is House Bill 2319. Mr. Chair, this is a firearms bill. It's not a criminal penalty, although I believe it was in Section 18.2. It deals with access to firearms and allowing access to firearms to somebody, not a child, but somebody who, by virtue of their legal record, would not be eligible to own a firearm or possess a firearm. It would specify, I believe, a $500 civil penalty. There were some concerns about, first of all, how do you check people? Do you have to do a criminal background check? I mean, what is the standard of knowledge that would be required? And also, you're holding people liable for other people coming into their house, whether or not they're a romantic partner, a roommate, or somebody else who may have a firearm. You may or may not know about it. So I think there's a little bit of uneasiness. Having said that, we had a 3-3 tie vote, so I have no recommendation.
Mr. Chairman.
Senator
Sorrell. Thank you, Mr. Chairman. I have an amendment. I would like on line 11 of the bill to move to amend, strike the word individual, where it says it is unlawful for any individual. It needs to say it is unlawful for any firearm owner. So instead of individual, it would say firearm owner. I would make that motion. And speaking to that motion.
Yeah, explain it better. Go ahead, Senator Sorrell.
Mr. Chairman, the reason the bill needs that amendment, because the way the bill reads right now, you could have, say, 4 people living in a house. One person owns a gun, one person's a felon. If a felon gets the gun owner's gun, all 3 or 4 people in the house would be liable under this bill instead of just the gun owner. And I think if there's going to be liability, it ought to be on the gun owner and not every other person that lives in the house. And that would be my amendment.
Mr. Chair,
Yeah, I think that defeats the purpose. Well, Mr. Chair.
Go ahead,
I've got a
Senator
question
Dees.
about the
Senator Dees.
amendment.
Senator
I mean,
Dees.
is the term gun owner defined anywhere?
Firearm owner, I said.
Firearm owner? What if you own a firearm that's in a house 10 miles away, but you're a firearm owner? But
All right, Kristen, do you have anything in writing on this? Because I haven't seen anything. If we're going to have an amendment, I'd like to just take a look at it.
No, Mr. Chairman.
Okay.
Yeah, Mr. Chairman, it was a 2-word amendment. I thought it'd be pretty simple.
Well, the problem with the bill is this. It says any person who allows a convicted felon to have a gun. I think that's the way it's written. But convicted felons cannot have a gun by law. I used to prosecute these, and I've defended people who were charged with being felons in possession of a gun. And that's clearly a federal felony. And if somebody aids and abets that person, that could be a crime too. And the way it's written is any person, a human being who's not convicted, who allows a convicted felon to have the gun. I don't understand conceptually how that really works. If you're going to have an amendment, I'd like to take a look at it first.
Mr. Chairman, it's worse than that because it addresses anyone who knows or has reason to believe that the person is prohibited. I mean, it doesn't even have to be a good reason to believe. I mean, it could be that it was in the newspaper 4 years ago.
Yeah. Okay.
Mr. Chair.
Yes. Yes. Who's this?
Peterson.
Senator Peterson.
I think we could probably spend a lot of time on this bill. Frankly, I think it's very overbroad. It would literally, in my opinion, require you to do a criminal background check on anyone that came into your house.
So you have a motion to...
The patrons even said that.
Right, and so I have a motion to pass by.
Okay,
Second.
It's been moved and seconded to pass the bill by, in House Bill 2319 to pass it by indefinitely, PBI. All in favor of the motion to PBI the bill, vote aye. All opposed, no.
Ayes 11, noes 4.
11 to 4 to PBI the bill. Okay, going back to...
That's our report.
Yeah, thank you, Senator Peterson. Block 1, bills we referred to finance. Which one should we take up? House Bill 2017. I don't have an explanation here, do I? What's the bill about? 2017.
Mr. Chairman, on the next page, you should see all of the summaries of the bills. The first page is just the cover sheet with the blocks.
Yeah, okay. All right, 2017, is Delegate Mullen here? Somebody to explain the bill? These got to be referred to finance, so we got to get them out today, one way or the other. Okay. Christian, can you explain the bill?
Mr. Chair, Charles here. House
Charles.
Bill 17. There is some amendments posted to LIS for the bill. There's some technical amendments, but the bill basically authorizes a jurisdiction to establish a youth justice diversion program, which is defined in the bill. And basically the intent of the bill is to establish these diversion programs throughout the Commonwealth. And that's that's what the bill does. It sets up a program to have juveniles diverted into these programs.
Well, it passed the House unanimously. Sounds like a good bill, although I'd like to have a copy of it. I don't have a copy of the bill. I don't believe. Maybe I do here somewhere. 2017. All right, take a look. All right, here it is. I'm sorry, I got it here. 2017. Okay.
Mr. Chairman?
Yeah. Yeah, here it is. Yeah, Delegate Mullen. 2017, Delegate Mullen. Explain your bill.
Thank you, Mr. Chair. Mr. Chair, what this bill does is it allows.
Let's do one at a time.
Sorry, we have two committees that are going at the same time, so I apologize.
Okay.
Well, we all have to get somewhere.
So what this bill does is it allows pretrial court services units to be able to set up another type of deferral for certain small crimes, so as to allow juveniles to be able to have other juveniles participate in the process. We work with the Office of the Executive Secretary of the Supreme Court, as well as a number of other agencies and groups that work with juveniles. And so what this does is it sets up sort of like an honor court for kids. And it's only if they choose to participate, only if their parents agree to participate, and that the court services unit agrees to it as well. This is pre-adjudication. And so it still allows for every other type of adjudication. It's just another tool in the toolbox of court services units to be able to help kids through the deferral process if they so wish. It's not mandatory.
Yeah, anybody besides Delegate Mullins want to say anything about the bill, one way or the other?
Mr. Chairman, may I ask a patron a question?
Senator Morsi.
All right. Delegate Mullen, it sounds like what we're conducting here is allowing the pretrial court services unit to set up with volunteers, other juveniles, volunteer lawyers, mock juries almost. Is that right?
Yeah, Mr. Chair, I would respond yes, but it's only if they agree to it. And I would qualify it more like an honor court, like they have it in colleges and universities. And it's still a deferral process. So it's pre-adjudication. The entire adjudication process is still there.
Okay. Anybody?
Follow-up question, very brief.
Morsi, go ahead.
Have you spoken with pretrial court services units as to how much time is going to, you have to engage in this and whether they are in favor of this?
Mr. Chair, I would answer the senator that I have, and the ones that want it are down here in Hampton Roads, and the ones who don't want it don't have to participate. This is not a mandatory means of being able to set up a deferral unless you want to.
Okay.
Thank you.
Any other questions of the patron? Is anybody, Delegate Mullen, want to speak in favor, or is anybody against the bill?
Mr. Chair, I believe that there's a representative from the city of Newport News who'd like to be able to speak in favor of it. Okay. I believe the Executive Secretary is neutral, and I believe there is also a potential amendment to remove any fiscal impact.
Okay. You want to offer the amendment?
Mr.
Yes.
Chair, the amendments have already been posted to LIS at the request of Delegate Mullen.
Okay.
Mr. Chairman, I move the amendment.
Okay. All right. It's been moved and seconded that the amendment be adopted. All in favor say aye. Aye. All opposed, no. Motion carries.
Mr. Chairman, I
Okay.
move to report the bill.
Okay, it's been moved. And is there a second? Senator Sasslaw seconds the motion to report the bill. House Bill
And to
2017.
go to finance.
Yeah, House Bill 2017 be reported as amended and to be re-referred to finance.
Yes.
Yes.
Servo.
So go ahead.
I'm okay voting this because I looked at the draft of it earlier. I would just note that I'm not able to pull up the bill on LIS. I'm able to pull up the amendment, but not the underlying bill. So hopefully
Okay.
staff can look into that, but I've read it already, so.
Okay, all right, good. All in favor of the motion to report the bill as amended and re-refer to finance? All in favor of that motion, vote aye. All opposed, no.
Ayes 15, no zero.
Okay, thank you. All right, House Bill 2056, Delegate Scott. I have that here, okay. Delegate Scott.
Thank you, Mr. Chair.
Mhm.
House Bill 2056. I've talked to Mr. Benjamin. He has a suggested amendment that I think we need to add that will clear some things up. But what this bill does is it is a bill that will basically alter the way probation is done in the state. Right now, we have about 60,000 people on probation in the state of Virginia. We have about 6,000 plus in the Department of Corrections for having committed no new offense. What this bill does is say that if you commit a technical offense only, then you do not have to. The judge doesn't give you any new time on a suspended sentence. The first offense, the second offense, he can give you a cap of 14 days, and the third offense, the judge can give you any time that he could have given you under the original time that you had for your suspended sentence. So what this does is add some fairness to our system, allows folks to move on in their life, and provide some certainty and ending to probation right now. So I'm hoping that the body will vote to report this bill, and I would ask that Mr. Benjamin report the amendments and explain them to the committee.
Okay.
And I know there are probably some people who want to speak to the bill.
Mr. Benjamin, one of
Yes, Mr. Chairman, and I think we're dealing with House Bill 2038. Is that right?
2056.
Yeah, that's where I'm confused.
I'm sorry, I'm on the wrong bill.
Yeah,
I'm sorry.
Me too.
All right, I got three. I have three of them before y'all today.
Well, this
I'm
one's got to
sorry.
go to finance. That's why I'm going down the list. It has to be go to
I'm sorry.
finance. It's 2056. Has to
I'm
do
sorry.
with relating to status offenders, willful and
Oh,
material
I'm sorry.
violation.
The 2056 is a bill to end juvie detention for children who have determined there is and Senator Marsden and others know this, there is a determination in juvenile court where children are determined chin sealed and children in need of services. And the court will order counseling or other things, usually involving kids who may have run away. And there are a lot of young girls, especially African-American girls, who are put in some sex trafficking situations. They get in those situations. The court will order them to go through children in need of services. And then when they violate that order, what the courts will do is maybe put them in detention, even though they have committed not only no new, they have no criminal record and they've committed no criminal offense. But this is gets them into the school to prison pipeline, gets them into the detention system. And then from there, that's another traumatic event and it doesn't help. So Virginia is one of only a few states that still do this. The experts in the country, the largest juvenile judge organization, has recommended that we stop doing this, putting kids in jail for violating these court orders, and offer them more services. And that is why we are recommending that we report this bill. Thank you.
Mr. Chair.
Anybody? Yes, Senator Dietz.
Delegate Scott, I completely support your goal here, but what do you do with a kid that repeatedly runs away from foster care or some sort of group home or some unsecure place they're on where they are on probation? What do you do?
In this situation, Mr. Chair, I would respond to the senator. In the situations involving these children, they're not on probation. They haven't committed any crime. These are children who are in need of services, and normally when they're in need of services, they may have some things going on with school. They may usually have other traumatic events going on in their lives at home. And so the last thing we want to do, Senator and Mr. Chair, is then put them locked up with other kids who are in detention for violating the law, gang members and others. and now we put them in that situation. I think the better thing is to keep working with those children, keep providing those services. I think it's difficult to say that we're going to put you in jail for your own good to teach you a lesson.
Mr. Chair,
Senator Dees.
Delegate Scott, I agree with you, but you still got these kids that maybe their status offense is running away from a foster home or running away from an unsecure facility, and they keep running away. What do you do?
Delegate Scott.
I will respond again. If I think we have to continue to offer services. We can't give up on these kids and say that the best thing that we can do for their own good is put them in juvenile detention and keep putting them in juvenile detention, where then whatever trauma they're going through is exacerbated.
2013, 2013. Okay. All right, well, don't take very long. Okay, anybody else want any questions of the patron?
And that's why I brought this bill, Senator, because the experts from 30 some odd states say this is bad for children. It further traumatizes children, and that's why this bill was brought at the behest of a whole host of advocacy groups.
Okay. Yeah, anybody here to speak in favor of the bill? Delegate Scott, or anybody to speak against the bill? Go ahead.
Yes.
Very briefly.
Those who would speak in favor of the bill, please raise your hand using the Zoom feature, raise hand. Yasmin Vafa, please go ahead.
At some point.
Hi, thank you for the opportunity to speak today. I am here to urge you to support 2056. It's long been held that children should not be incarcerated for status offenses that are nonviolent, not serious behaviors that are often correlated with experiencing and enduring trauma. We talk about this phenomenon in our report, the Sexual Abuse to Prison Pipeline. We know across the country and here in Virginia that girls are overrepresented among status offenders, and many, many states, as Delegate Scott said, have eliminated this harmful, archaic, and outdated practice by eliminating the valid court order exception. More than 30 states have done so. It's time for Virginia to do its part and to eliminate this harmful practice that disproportionately harms girls and other survivors of trauma and abuse. It's not only not cost effective, it's inhumane.
Who do you represent again?
Rights for Girls. We're a human rights organization in the DMV
and
area.
Your name again is, I'm sorry.
Yasmin Vafa, thank you.
Okay. All right, anybody else want to speak in favor or against the bill?
Legal Aid Justice Center, please go ahead.
How many people are going to speak in favor of this bill?
Currently, we have about 6 speakers to the bill.
Okay, 15 minutes apiece, so I think we understand the bill. Go ahead, very quickly. 15
Yes.
seconds. Yeah, 15. Make it quickly. Don't put a time frame. Go ahead.
Yes, this is Amy Walters with the Legal Aid Justice Center. Our position is in support. Even a few days of detention can cause irreparable harm for youth, and there are places other than detention to serve this youth, getting to Senator Deed's point. Thank you.
Okay, thank you. Next, very quickly.
Valerie Slater.
Mr. Speaker, thank you. Valerie Slater, Executive Director of Rise for Youth, board member of the Activated People, and member of the Virginia State Conference NAACP, also speaking in support of the bill. There are many ways to support young people who find themselves in trouble and have committed absolutely no crime. That does not include incarcerating them.
Right.
Incarceration significantly increases a child's likelihood of being further involved in the justice system, and we must stop this practice.
Thank you very much, and I think we get it. Anybody else? Very quickly.
Eric Reynolds.
Good afternoon, Mr. Chair, members of the committee. Eric Reynolds of the Office of the Executive Secretary, Supreme Court of Virginia. The court opposes this bill. The Juvenile Domestic Relations District Court judges who reviewed the bill only use this provision as a last resort to hold the youth accountable for a violation of a court order. Again, the clarification here is that this is for a violation of a court order, not the underlying status offense. For most, if not all of these cases that reach this point, there have been multiple interventions, FAT meetings, multidisciplinary team meetings. If you're talking about truancy youth,
do you have an amendment?
Multiple meetings with the school divisions, and this culminates.
Let me ask you, do you have an amendment or something to fix the problem or not?
We have no amendment, sir.
Mr. Chair.
All right, yes.
Brief question of the speaker.
Go ahead.
You've heard other people talk about it being inhumane to incarcerate a juvenile. Just respond briefly, a sentence or two, to that point, as opposed to it being okay to lock them up even for multiple violations of a court order if they're a status.
Well, I would speak to a policy behind it. I will say that the juvenile court judges that reviewed this bill have stated that for the cases where it was appropriate, detention was effective to get the children back into school. and some children to stop running away. It did do its purpose, which was to deter the behaviors that brought them before the court in the first place. Now, I'll say again, not all courts use detention. Again, it's a case-by-case determination. And the point they wanted to make was that they would like to continue to have this as an option, just as an option for those cases where it would be effective or it would be the right decision.
Thank you, Mr. Chairman.
Anybody else want to speak for or against the bill? And very quickly.
Sean Winetta, please go ahead.
Sean Winetta speaking on behalf of the Humanization Project, and we support this bill. Thank you.
Okay. Anybody else want to speak in favor or against the bill?
Eileen Longnecker, please go ahead.
Eileen Longenecker with the OES at the Supreme Court. Mr. Reynolds already addressed issues on behalf of the court system. Thank you.
The court's against the bill, right?
Correct.
Okay. Anybody else want to speak on the bill, one way or the other?
Eugene Oliver.
Very briefly.
Mr. Oliver, we can't hear you.
How many more after this? Is this it?
Eugene Oliver is our last speaker on this bill.
Okay, all right, briefly. She for or against?
Eugene Oliver, could you raise your hand if you are in favor of this bill? He is raising his hand right now.
Okay, briefly.
His mic does not appear to be working.
Okay. All right, before the body, I thought it was a good bill, but I'm reluctant to.
May I say one other thing,
Yes,
Mr.
go
Chair?
ahead, Delegate Scott.
The National Council of Juvenile and Family Court Judges, the largest organization of juvenile court judges in the country, made up of about all member states, they endorse this policy. I understand that the local judges, they still want to do this, but we can't continue to lock up kids for their own good when we have so many other tools at our disposal. So I'm hopeful that the court will not continue to lock up kids who committed no offense. And most of those kids are looking like me and will never get out of this.
Is there a motion?
Yeah, motion to report, Mr. Chairman.
Be reported, Mr. Chairman.
Wait, one at a time. Okay, there's a motion.
I said I move the bill be reported, Mr. Chairman.
There's been a motion been made to report the bill. Is there a second? Okay, there's motion and second to report the bill. No amendments, right? Okay.
Mr. Chairman,
yeah,
you go to
and it got to be re-referred to finance, right?
Move the bill be reported and re-referred to finance, Mr.
There's
Chairman.
been motion and seconded to report and re-refer the bill to finance. Of this bill, House Bill 2056. All in favor of the motion, vote aye. All opposed, no.
Seven no, 7, 1 abstention.
7, 7, and 1. Okay. It fails. The bill fails 7, 7, and 1. Okay.
Thank you, Mr. Chair and the committee.
Thank you, Delegate Scott. Now, Delegate Herring, Charnel Herring, HB 2113. I think I know what the bill is. Delegate Herring, tell us about the bill.
Thank you, Mr. Chair and members of the committee. And I just want to first thank Delegate Servo and the Crime Commission and Senator Deeds for all this work, because I think finally we have a bill that's a solid bill, it will provide Virginians a clean slate. The House and Senate have come to a strong compromise that reimagines our criminal justice system to remove barriers and address systematic inequities to provide a clean slate for Virginians who have paid their debt to society or have had charges deferred or dismissed. This bill will provide for automatic sealing of certain misdemeanor convictions after 7 years have passed if no other convictions have occurred during that time. The eligible offenses include underage possession of alcohol, false ID to obtain alcohol, petty larceny and concealment, trespass, instigating trespass, and trespass on posted property, possession of and possession with intent to distribute marijuana, and disorderly conduct. The bill also creates various processes to automatically seal charges that do not result in conviction or deferral and dismissal, including misdemeanor offenses and mistaken identity offenses moving forward. Misdemeanor offenses retroactively if the person has no convictions on their Virginia criminal record and no charges in the past 3 years. Acquittals and dismissals with prejudice for felony offenses with the concurrence of the Commonwealth Attorney moving forward. This will also allow individuals to petition the court for enhanced sealing of misdemeanor convictions after 7 years and certain felony convictions after 10 years if a person has no further convictions in Virginia or other states. Offenses eligible for petition based on base sealing include all the misdemeanor offenses, all class 5 and 6 felonies, grand larceny, and any other offense punishable as larceny. I will note DUI related offenses and domestic assault and battery are not eligible for petition-based sealing or automatic sealing. A fund under this bill, a fund is established to cover fees and costs for indigent individuals. As we all know, even a minor criminal record can present a lifetime of barriers of obtaining jobs, housing, education, and other opportunities. Maintaining public safety, of course, is paramount, but recidivism probably declines over time. There's some point in a person's criminal record who remains free of further contact with the criminal justice system if there is no greater risk of reoffending than any other person. Mr. Chair, I know that you have a busy docket. I'll just commend the bill to the committee. I think we do have representatives from the Virginia State Crime Commission who has been working with us for almost now a year on starting to have an expungement system in Virginia.
Okay, the Crime Commission supports the bill, right?
Well, they've been helpful. They supported the underlying
right,
bill,
the
which was
concept.
endorsed the expungement
Right.
section, but some of those crimes that were initially in the bill were moved to the
Okay. Now, is there anybody briefly to say something about the bill? Because we don't have but so much
Chairman?
time. It's got to go to finance. Yes.
Yes, a couple of questions of the patron.
Go ahead, Senator Morrissey.
Delegate Herring, you know that I support expungement, but I have a couple of questions.
Sure.
This automatic expungement does not cover misdemeanor convictions for domestic violence, is that right?
That is correct.
In a sentence or two, why is there a carve-out for domestic violence on a misdemeanor whilst at the same time allowing for expungement of certain felonies with the concurrence of the CA?
Well, and thank you, Senator. And Mr. Chair, I answered the Senator that in deliberations, and I can only speak for the Crime Commission part of the study, we were concerned about stacking crimes and the unique nature of domestic assault and battery. And we thought that would be better if we take that and continue that crime as part of the study, which is still continuing. The same with DUI. It's a stacking crime. The penalties increase, and we thought it would be better treated. We thought we needed more time to determine how we would handle that. So it was a policy decision that was made.
Follow-up question.
Thank you. Very briefly, go ahead, Senator Morrissey, very quickly.
Delegate Herring, you realize that carving out for domestic violence catches sibling assaults, daughter, stepfather, not just the traditional, spousal abuse. You realize that, right?
Yeah.
I'm very, very familiar. Worked
Okay.
as a law clerk while in law school and that court. I am very familiar, yes.
All right. Thank you, Mr. Chairman.
Okay,
Thank you,
as
Delegate.
I understand, the study will continue, so this may not be the final version. Okay, is there any further?
Mr. Chairman.
Anybody else need to say something? Senator
Sorrell.
Go ahead.
Thank you, Mr. Chairman. I just want to say can't tell you how much I appreciate the work of both Chairman Herring and the speaker on this. We probably spent 6 or 8 hours working through the details of this, coming to a compromise. Mr. Rubin was also very useful, and the Crime Commission staff has just put ungodly hours into this to get this thing into a position where we can pass it. This is a fairly major piece of legislation, and
So is there a motion?
I move
the
to
bill be
report it
reported.
and re-refer to finance.
Been moved.
Second.
Is this a substitute? Is this a substitute we're dealing with?
I don't believe we've adopted the substitute yet, Mr. Chairman, so I would move to adopt the substitute.
Okay, is there a second? All in favor of the motion to adopt the substitute, say aye.
Aye.
All opposed, no. Motion carries. So there's a motion
Move
to
report and re-refer.
report
So
the
moved, Mr.
substitute
Chairman.
and re-refer to finance. It's been moved and seconded. Report and re-refer the substitute to finance to House Bill 2113. All in favor vote aye. All opposed vote no.
Ayes 10, noes 4.
10 to 4. 10 to 4. The bill has been reported and re-referred. Congratulations.
Thank you, Mr.
Delegate
Chairman,
Herring.
members.
Thanks for the good work you
Appreciate
did. Okay?
Thank you.
All right, thank you. And now the next bill is Rome, House Bill 2132. Delegate Rome.
Yes, thank you, Mr. Chairman. Mr. Chairman, we have the amendments that were before the committee last time on Monday, and we have some additional amendments to make as well today that we worked on with Mr. Benjamin, and I would just request for the amendments to be reported. And
okay, Delegate or Senator Benjamin.
Mr. Chairman, I will include all of the amendments so everybody is clear on what is being done, unless there's an objection to that.
Go ahead, please.
Okay. On line 15, after A, strike the remainder of line 15 and through the word another on line 16 and insert the word another with a capital A.
Okay.
Okay. Next, on line 16, after the word orientation, strike the remainder of line 16 through the word accurate on line 17.
Okay.
On line 17, after the word not, insert the following words: in and of itself, comma, or together with an oral solicitation, comma.
Okay.
On line 18, after the word not, insert those same words: in and of itself, comma, or together with an oral solicitation.
Okay. Is there a motion? Is that
On
it?
line 24, after subsection A, strike the remainder of line 24 through the word another that appears on line 25 and insert the word another with a capital A. On line 25, after the word orientation, strike the remainder of that line 25 through the word accurate that appears on line 26. And on line 26, after the word not, insert the words in and of itself, comma, or together with an oral solicitation. I think that the only new amendment you're hearing now is the insertion of the clause or together with an oral solicitation.
Okay.
Mr. Chair.
Yeah, Senator Morse, you moved
Question
the
for
amendments.
question for Mr. Benjamin.
Go ahead.
Steve, is there anything in this language, including the amendments, that would prohibit a defendant from saying in court, I'm not guilty because I felt this way or I did this way? In other words, is there anything that limits the defendant from saying he didn't have the requisite mens rea with this law or these amendments?
Mr. Chairman, Senator Morrissey, it does not prohibit a defendant from defending on the basis that he did not have the requisite mens rea. What the bill does do is say that that reason cannot be another person's sex or the other character traits, or that person's sex together with an oral solicitation.
Okay.
But it permits consideration of any other factor that is relevant to the defense or the crime that is charged.
Okay, is there a motion to adopt these line amendments? Second, all in favor of the motion and seconded to adopt these line amendments that Steve Benjamin just explained. All in favor of the motion, vote aye, or say aye. All opposed, no. Motion's carry. Okay.
Mr. Chair.
Yeah, Senator Mercerville.
Peterson.
Okay.
And I did talk with Delegate Rome, and I'm looking at this. This only has to do with murder cases, homicides?
No, Mr. Chairman, I would tell the senator that this has to do with assaults as well as murders.
Okay, follow-up question, Mr. Chair.
Senator Peterson.
Peterson. And we have, for example, hate crimes where your knowledge of a person's race or gender can actually be a mens rea that would cause you to be charged with a hate crime. If you attack somebody based on, again, some immutable characteristic that they have, such as gender or race, that could be then basically an enhanced penalty. So I guess how would we deal with that situation if there's some type of situation where somebody didn't know the gender, or there was the gender was revealed to them, and that would actually be their defense to being charged with a hate crime? How do we deal with that situation?
Sure. So, Mr. Chairman.
Delegate Rome, go ahead.
Thank you, Mr. Chairman. So, Mr. Chairman, I would tell the senator that one thing that's important to keep in mind when we're dealing with the LGBTQ panic defense here is that it's a separate legal issue from hate crimes. So basically, you know, what we like to think here is that when you're applying a strictly like heteronormative lens to arguing that the panic defense would be like not necessarily short-sightedness because of how it would affect hate crimes, we know that LGBTQ individuals are highly susceptible to violent acts committed against them because of their perceived or actual identifiers. By comparison, cisgender or heterosexual people do not have to worry each day that they may be assaulted or killed just simply because, you know, someone is surprised when their presence comes, right? And so, but I would basically just argue in this case, just to deal with the hate crimes aspect of it, is that when you are dealing with a hate crime, you're dealing with someone who has targeted a specific group of people, right, for the intention of doing that. What this person in this case, you know, who has assaulted or killed someone is saying is that, oh, well, yes, I did do that, but because of their identifier, because they were gay or because they were trans or, you know, take your pick, that it's not only okay that I did it, but it excuses the action. And we want to eliminate that because we think that this is not okay under any circumstance to turn the victim in this case to the person who's being on trial, more or less, as opposed to
Delegate. My question is not. I understand that. Believe me, I'm not trying to excuse assault under any circumstance. But I guess my question is, if someone's charged with a hate crime and they said, "Well, it's not because I thought that person was a man and it turned out to be a woman, or I thought it was a woman and it turned out to be a man," I'm not going to presume that the assailant is a man, you know, depending on their gender. I guess, again, we do have crimes where we charge people based on they had a perception of somebody's race or gender, and that would be one of the elements that would have to be proven by the prosecution. And I'm not sure if this statute is kind of at cross purposes with that.
So
maybe I'm
Mr.
not.
Chairman,
Rome, go ahead.
Yeah, sure, Mr. Chairman. I would just tell the senator in this that because we are dealing with a separate, you know, legal concept as opposed to hate crimes in this, we're dealing more or less with the admission of evidence. What we are basically saying here is that if you are going to try to make this defense, which you could bring up in court, what's simply going to happen is that the judge is going to instruct the jury in this case of just basically saying, we are, you know, they can present this, but it is not going to be something where you can excuse what their action based on that. So I do not believe that this conflicts with existing hate crime statute, and that this, because we are dealing with basically courtroom procedure at that point, it's completely separate from how we would charge someone.
Mr. Chairman.
All right, Senator Morrissey, let's move along quickly.
I understand. Question for the patron.
Go ahead.
Delegate Rome, there is not an individual in this room who doesn't believe that anybody who attacks or kills or assaults somebody because of sex, gender identity, or sexual orientation isn't in the wrong. That's not my concern here, and I need you to answer the following question. I'm concerned about telling a defendant, you cannot make this defense, even though we all agree that the defense is ridiculous, it's silly. I'm concerned that we're going down a path telling somebody, you can't even make that defense. Can you address my concern?
Yeah, absolutely. So, sure. So first off, I would just tell the person this is that when you are dealing with LGBTQ victims in particular with this, the person in this case, or the defense in this case, is trying to play on pre-existing biases of a judge or a jury. That is separate and different from how it's dealt with when you're dealing with race, when you're dealing with religion, when you're dealing with basically other identifiers. And so educating jurors and members of society about the dangers basically of this violence that, you know, people like me actually face. What we're basically saying that is that any miscarriage of justice toward these people should be concerning to everyone, and that this especially goes toward practicing attorneys who are going to try to play on that bias from a jury or from a judge in the first place. Whereas it's different for other groups where you could go and, it doesn't matter what 133 localities you're going to be in Virginia, you could have that case dismissed. But as we have found in Virginia, that's not always the case, because you are playing differently to a different judge, different jury, who, even though the committee and, myself, obviously, very much agree that you shouldn't just be able to blame someone's, sex, gender identity or sexual orientation as the reason for and excuse for that person's, murder or assault. But there are other people who, as we have seen, not just in Virginia, but across the country, where that strategy has worked. And we want to basically say that, no, that's not okay.
Okay, now, is anybody who would like to, who's out there would like to say anything one way or the other? How many people do we have to speak?
Yes, Mr. Chair, we have 4 speakers to the bill.
Okay, can you do it in 15 seconds? Okay,
Mr. Chairman,
30 seconds each person. Yeah, guys.
Mr. Chairman, I have a question.
Yeah, go ahead, Delegate Rome.
Thank you, Mr. Chairman. Mr. Chairman, I certainly don't mind the, trying to expedite. We do also have Judy Shepard, who's Matthew Shepard's mother, who would like to testify as well. So if she could just have a little bit extra time, that'd be
Yeah, go ahead, Ms. Shepard. Go ahead and speak. Yeah, go ahead. I didn't know you were here. Thanks for coming.
She's being moved into the room right now.
Okay. If she's not available right away, is there somebody else?
No, I'm here.
Okay, Judy Shepard, thank you. We're honored for you to be here. We appreciate the time you've taken to be with us. Thank you very much.
Thank you. I apologize. My internet just blinked. Thank you for the honor to testify.
Take as much time as you want, but we have a short time frame here. But go ahead. I'm not going to hold you to 30 seconds. Go ahead.
Thank you. That's very kind. I appreciate your shortness, and I will be as brief as I can. I want to thank you for this honor to be allowed to speak. I am president and co-founder of the Matthew Shepard Foundation. I want to thank Delegate Rome and Delegate Mullins and other leaders who've introduced this bill to ban the indefensible panic defense for LGBTQ plus victims. When my son Matthew was murdered in 1998, his 2 assailants attempted this defense. Gay panic, really, seriously? You're going to say because Matt was gay, you were driven to murder him, and this level of brutality, and especially that just because he was gay, you're going to do this and think you're going to get away with it? Well, the judge would have nothing to do with it, but this is one of the cases where years ago it would have worked, and it is still working in today's courtrooms. To say that the victim is the reason for why this happened, to not only be the victim, but the cause of the case, is just beyond the pale. And I know y'all agree, and hate crimes, you have hate crimes, and you think this is going to cover it, and gay panic is something totally different. The gay community lives in apprehension and fear every day that they're going to be singled out for exactly this kind of activity. And to think that their assailant is just going to say, well, I did it because, they're gay and everybody knows that that's wrong. Well, that is wrong. That has no place in today's society. I apologize if I sound angry, but I am angry that the assailants thought that that was going to work. That because Matt was gay, they had the right to do that to him. In a very plain terms that I try to use to explain to folks who don't get this, not just you in this room, but just folks who don't understand how absolutely horrendous this defense is imagine that you are a woman in a bar and someone is hitting on you, and you are like, I'm the woman and I'm so upset you're hitting on me that I'm just going to beat you to death. Really? Now it's different because the victim is gay, that this is going to work? It doesn't work. It doesn't work. It puts everybody in danger, and it harms the victim all over again. Because Matt was actually murdered, we don't know the long-term effects of someone getting away with the gay panic when they have assaulted someone. That is not our level of experience. But they are actually claiming that the sexual orientation, gender identity, or expression explains and excuses a loss of self-control. That is not an excuse. That is not an excuse. And they should not be allowed to get away with it.
Thank you so very, very much, Mrs.
Thank you.
Matthews. Yeah, thank you. We appreciate you being here. We're honored that you were able to come.
Mr. Chairman?
Yeah, go ahead, Delegate Rome.
Thank you, Mr. Chairman. We also, if anyone has questions about when and where this has been used before, we have an expert witness on this, Warren Anderson, also known as Carson Anderson, who's with us as well, who can speak on that.
Mr. Chair, I'd like for him to address whether this defense has ever been raised or been attempted to be raised in Virginia.
Okay, Senator Dees has that question. Has it been raised in Virginia? Does anybody know?
Mr. Chairman, the answer to that is yes. We had, we sent, basically, Carson sent all the committee members, just a number of cases that he had found through his own research. If he's on, I'll be
okay. Yeah, please go ahead. Can you do it in 30 seconds?
Yes.
Okay, good. Thank you.
Mr. Chair, he's being moved in the room right now.
Okay.
Warren Anderson, whenever you're ready, please go ahead.
Okay. Go ahead.
Mr. Anderson, please unmute and go ahead.
Sorry, folks. Carson Andreessen here. Can you hear me?
Yeah, go ahead. We're listening.
Okay. It's been used it's actually been used 9 times. I found an additional case, but it's been used 5 murders and 4 assaults. I sent out an email yesterday that had the 5 murders and 3 of those assaults.
Okay. All right.
And it's basically in those instances where it was used, it resulted in what I would assume would be low sentences for people that committed murder. The lowest was 14 years. And then somebody received a sentence of 60 years. So that was the longest.
Okay, thank you. Thank you. I think the bill's in good shape. Senator Morrissey has a question to Steve Benjamin, I think.
I have one question for Steve Benjamin.
Go ahead. Go ahead, ask the question.
Certainly. Steve, is there anywhere else in the Virginia Code or a model jury instruction where somebody is precluded from raising a defense?
Yeah, Steve?
I can't think of one.
I'm sorry.
Mr. Chairman, I cannot think of such an instance.
Mr. Chairman?
Delegate Rome.
Yes, Mr. Chairman. There's a couple of different examples you could use. For one, the example is the rape shield law, where basically you can't, like one of the things that you can't use is a rape survivor or rape victim's history and what she was wearing, what all the other sort of stuff, that contributed to her background before a perpetrator were to go to attack her. That's one, example where we don't do that. Another one is bribery. So basically you can't use, I was bribed, and therefore that is either an excuse or a reason for why I do this. So yes, we do have examples in the Code of Virginia that are applicable here.
Okay, I think the bill's in good shape. Are we ready to go ahead and vote?
Move to report.
Been moved and seconded to report the bill. Has it been amended? I can't remember. Okay.
Yes, as amended.
As amended. All in favor of the motion to report?
And refer to finance, Mr. Chairman.
Report and then refer the bill as amended to finance. All in favor?
Mr. Chairman?
Yeah, you go ahead, Delegate Rome.
Mr. Chairman, I'm not sure that this would actually have to go to finance in the first place because it does not.
They requested.
Delegate Rome, they've asked for it.
They have requested, so we.
Okay, I understand.
Okay. The motion been made and seconded to report and re-refer the bill as amended to finance. All in favor of the motion, vote aye. All opposed, no.
Ayes 9, noes 5, 1 abstention.
Okay, thank you. Congratulations, Delegate Rome. Thanks for your
Thank you, Mr. Chairman.
presentation. We appreciate it very much. House Bill 2276, Delegate Simon. This has also got to go to finance. Delegate Simon. House Bill.
I am here, Mr. Chairman.
Okay, Delegate Simon.
House Bill 2276, that is not the one I was preparing for, but I've got that. That is the bill on ghost guns. And what HB 2276 does is it makes it illegal to possess, transport, sell, and so forth, unserialized firearms, and they're called these 80% receivers. Essentially, what's happened here is as you guys know, we've passed a number of gun violence prevention pieces over the last year or two, and we require background checks universally. We closed the gun show loophole and so forth. What folks that want to get around that can do is they go online to a place called ghostguns.com, and you can buy the lower, right, the receiver, the part that holds and chambers the bullet, which is the gun. It's required by law to have a serial number, unless it's not 100% complete. And so you buy these 80% kits, which come with the bored out, ready to go receiver and a drill bit, a couple drill bits, and a drill and a guide and a cinch and everything, so you can finish it yourself. So you spend about an hour or 2, 3 finishing that receiver, and then you build the gun yourself, and it's got no serial number. You required no background check. There was no age limit to purchase it. It's untraceable, and it really evades the entire system. Hobbyists will tell you, well, I like to it's just a hobby. Have no ill intent. I just like to build guns. You can buy 100% complete receivers as part of these kits. You can buy one that's finished. It doesn't require this extra work if you have a serial number on it.
Right.
And when you're finished with it, you can get a serial number for anything you build. So what this just does is it makes it illegal to have these unserialized guns to evade all of our great gun safety regulations. I hope you might have.
Is there an amendment required? Anybody have an amendment? Okay, is anybody like to, any questions of the patron? Anybody like to speak in favor of the bill? I'm familiar with what you're talking about. I've researched this issue too.
Those who would like to speak in favor of the bill, please use the Zoom feature, raise hand.
How many are there?
Mr. Chair, it looks like we have 12 or 13 to speak to the bill.
All right, 30 seconds apiece, and make it as short as possible, please.
Scott Miles, please go ahead.
Good afternoon, Chairman Edwards, members of the committee. Scott Miles here on behalf of Attorney General Mark Herring. The Attorney General supports this bill. Thank you very much.
Thank you very much. Next.
Lori Haas, please go ahead.
Lori Haas.
Good afternoon, Mr. Chairman and members of the committee. My name is Lori Haas. I'm with the Coalition to Stop Gun Violence. We wholeheartedly support the bill. One aspect to make note of, this is a law enforcement bill. When unserialized firearms are found at crime scenes, the cases go cold. They cannot trace these weapons, and it is presenting a serious problem in cities up and down the East Coast. We need to get in front of this problem. We need to make unserialized firearms illegal in the Commonwealth. Hobbyists can still use and buy the kits that are already serialized and easily get these serialized. They can make their firearms as hobbyists like to do. And we urge the committee to pass this bill.
Okay.
Thank you.
Thank you. I agree with you 100%. Thank you very much. Next.
Amber Baumer, please go ahead.
Good afternoon. My name is Amber Baumer. Moms Man Action supports HB 2276 that will allow Virginia law enforcement to hold individuals accountable for carrying firearms known as ghost guns that when disassembled would not otherwise be identified or detected as firearms.
Okay.
Additionally, prohibiting the sale of unfinished frames and receivers which are not engraved with serial numbers can be purchased without background checks, which will help keep these dangerous gun parts out of the hands of people with dangerous histories.
Thank you.
This closes a major loophole in the ATF's current interpretation of federal law.
Thank you very much. Next. Try to make it quick.
Once more, those who would like to speak in favor of the bill, please raise your hands using the Zoom feature, raise hand.
If you would like, you can just state your name and who you represent and whether you're for or against without going into detail, because I think we understand it.
Heather Foglio, please go ahead.
Hi, my name is Heather Folio. I am a volunteer with Moms Demand Action for Gun Sense in America. Ghost guns are the fastest growing gun safety issue that we're currently facing, and we urge you to please support this bill.
Thank you very much. Thank you. Next.
Maggie Hoover, please go ahead.
Hello, Chair Edwards and Senators. I'm Maggie Hoover for the League of Women Voters of Virginia. And ghost guns are a threat to public safety and law enforcement as it allows important laws to be circumvented. The League urges you to stop this danger and to our communities and to pass this bill.
Thank you very much. Next.
Molly Voigt, please go ahead.
Thank you, Mr. Chair, members of the committee. I'm representing Giffords, the gun violence prevention organization started by former Congresswoman, gun violence survivor Gabby Giffords. My testimony is on behalf of our Giffords Law Center ghost guns expert, David Pacino. Would echo all that has already been stated and what Delegate Simon explained. And I also just wanted to note that this bill will not affect scratch builder craftsmen who create historically accurate firearms.
Okay, thank you.
It will also not affect modular modifications, which is one component swapped for another. It will only target unaccountable, untraceable firearms, and we hope you support it. Thank you.
Thank you very much. Next.
Kelly Roskam, please go ahead.
Good evening. My name is Kelly Roscom. I'm with the Educational Fund to Stop Gun Violence. We strongly support the bill and urge you to pass it.
Thank you. Next.
Andrew Goddard, please go ahead.
Mr. Chairman, Andrew Goddard, Virginia Centre for Public Safety. For all the reasons given above, we support this bill.
Thank you very much. Next.
Melanie Cornelise, please go ahead.
Hi there. On behalf of Moms Demand Action and Everytown Survivor Network, we support this bill. Thank you.
Thank you very much. Next.
Tanya Shard, please go ahead.
Hi there, Tanya Shart with the Brady Campaign to Prevent Gun Violence. Right now, anyone in Virginia, including prohibited purchasers, gun traffickers, those suffering a crisis and who may want to harm themselves, and even minors can easily buy any number of ghost gun kits and build any number of untraceable firearms.
All right. Thank you very much.
We strongly encourage the committee to report this bill. Thank you.
Does anybody else need to speak? How many more are there?
I believe that's all that want to speak in support of the bill.
Anybody against the bill?
DJ Spiker, please go ahead.
Yeah, all right, briefly. Go ahead.
Thank you, Mr. Chairman. DJ Spiker, National Rifle Association. This was glossed over in presentation. It's important to note this. 50 years of previously legal firearms will be illegal upon passage of this bill. This is a terrible policy and precedent. There are no provisions for grandfathering. There are no provisions on what an individual would need to do in order to incorporate it. There's no provision for how to incorporate hobbyists. There's a reason that only 5 states have done this. The District of Columbia has done this, and they're still having an issue. This does not address the problem and makes previously legal firearms illegal through confiscation immediately upon passage. This is a terrible bill that needs to be amended. Thank
Let
you.
me ask you a question. All you need to do is get a serial number printed on the gun, isn't it?
No, sir.
Go ahead. I'm sorry.
Mr. Chair.
So, Mr. Chair, sorry.
Go ahead. Yeah, but go ahead, Ms. Spiker.
So no, it's not just any individual can make up a serial number. There's a reason that FFLs are issued one through the federal government. There's a process that serial numbers have to go through.
Okay.
There's no instructions for an individual how to put a serial number on there, what steps to take. We're just telling them, if you own this after July 1, you're now a criminal.
Okay, thank you. All right, next. How many against the bill?
We have 3 more speakers against the bill. Vincent Smith, please go ahead.
Go ahead.
This hobby and these firearms are not a threat to public safety like proponents of this bill would have you think. Criminals are a threat to public safety, and that's what keeps getting glossed over in these discussions. This bill makes no allowance for serialization, and that's why this is a federal issue and should remain there. I strongly urge you to vote nay on this bill.
Okay, thank you. Next, who else?
Ryan Brook, please go ahead.
Yeah, Chairman and members of the committee. So manufacture of firearms is already heavily regulated under federal law. The ATF has clearly already stated unfinished receivers are not firearms. There's no federal requirement of serial numbers to be put onto personally manufactured firearms. With no grandfathering, as was said, unserialized homemade firearms that are currently owned lawfully will be immediately made illegal. Form 1 with the ATF only applies to NFA items and would not apply to these targeted homemade firearms. So there is no process but for Virginians to either lawfully destroy their own property or to not comply with this infringement of a hobby and practice older than our nation.
Okay.
Therefore, I urge you to oppose it. Thank you.
Thank you very much. I think Senator Peterson has a question.
Yeah, well, I guess it's a question. Maybe it's 2 points. One is, and we've addressed this issue before, if someone is legally either purchased or manufactured a product and they legally possess it, and then retroactively we go back and classify that possession as a felony. I mean, that has all sorts of due process concerns. Not everybody keeps track of what happens on July 1st when the laws change. So we ran into this issue last year. I think this law, to the extent we agree to go this way, we're going to have to make it prospective. That's number one. Number two, I don't see how you prevent somebody from possessing. If they're a convicted felon, that's one thing, but the possession of a firearm is a right that's protected under the Second Amendment. Now, the federal law has all sorts of laws and regulations that apply for transactions, commercial transactions. But someone who just self-makes a firearm for their own personal use, I don't see how, again, I think we're running into a constitutional issue there. So I think this bill as written is overbroad. Maybe it can be modified, but I think you're going to have some major constitutional issues.
All right, does there anybody have an idea for an amendment or anything like that? Steve Benjamin, anybody to deal with that issue?
Sure.
Okay, Steve.
Sure.
Charles. Okay.
No, Mr.
Okay.
No, Mr. Chair.
Okay, anybody else want to speak for or against the bill?
Mr. Chair, I think we have two more to speak against the bill.
Okay.
Philip Van Cleve, go ahead.
Very briefly, go ahead, Phil.
Philip Van Cleve, VCDL. Look, before 1968, no guns were required to be serialized. There's millions of them out there, and the world has not come to an end. And by the way, tracing only affects something after a crime's already been committed. It will not lower a crime rate to have a serial number on a gun. It may help get the gun back to the owner, but that's about it. So we strongly oppose this, and for the reasons that Senator Peterson suggested.
Okay, next, anybody?
David Adams, please go ahead.
Thank you, Mr. Chairman. My name is David Adams, the Virginia Shooting Sports Association. For all the reasons that have already been stated, we oppose this bill, and we concur with the comments of Senator Peterson.
Okay, next.
Those are all our speakers, Mr. Chair.
Okay, now we're at the point of doing something with the bill. Is there any kind of motion?
Mr. Chairman.
Yeah, Senator Serval.
Mr. Chairman, it smells to me from the comments I've heard from colleagues that at least the major concern is how this makes things illegal to possess. And it strikes me that the bill might be fixable to those folks if we struck possession from the bill and left everything else: sale, offer to sell, transfer, transport, etc. Just strike possession.
Where's that motion? Where would that motion be?
Sorry, Mr. Chairman.
Whereabouts in the bill?
It would appear in a couple places. It'd be on line 41.
You want to take a minute and pass this by temporarily?
No.
Okay, go ahead, Senator. Senator.
I would.
Serval.
I move to report.
Just Senator Serval, go ahead if you want to fix it.
I would ask the patron if he would consider that to be a friendly amendment.
Mr. Chairman, I would consider that to be a friendly amendment because it sounds like it might help this move forward and get to where it needs to be. And I don't think, again, we're not trying to felonize existing folks and to, so if we can get the other parts of it, that'd be fine with me.
Mr. Chairman, if you want to take this by temporarily so I can fashion the amendment, we can come back to it.
Take it by temporarily, okay. And now we'll move on temporarily to House Bill 2331, Delegate Mullen. This also got to go to Finance. 2331, Delegate Mullen.
Hello, Mr. Chair.
Yeah, thank you.
Mr. Chair, my understanding was that this bill was going to be conformed to your bill.
That's right.
This is mandatory minimum bill.
Okay, and then just adopt my bill when you're over there in the House, okay? All right, is there a motion to conform House Bill 2331 to Senate Bill 1443, which is my bill? It's been moved, and is there a second? All right, it's been moved and second to conform the minimum mandatory bill of Senator of mine to, or Delegate Mullins to mine. All in favor of the motion, say aye. Aye. All opposed, no. The bill is conformed. Is there a motion to report the bill and refer to Finance? It's been moved and seconded to report the substitute and re-refer to Finance. All in favor of the motion, vote aye. All opposed, no.
Ayes 10, noes 5.
10 to 5. You're very eloquent, Delegate Mullen. We appreciate it. Senator Serval, shall we continue? Okay, we'll wait.
No, Mr. Chairman, I'm working on the amendment still.
Okay, all right, you're doing a good job. Keep working. We're getting to that. We'll get to that.
Mr. Chairman?
Yes, Delegate
Senator Serval.
Senator Serval.
I believe another quick one was Delegate Fowler's bill. I think she wanted that PBI and sent to Boyd Graves.
Okay, House Bill 2073, Delegate Converse Fowler.
I don't know if she's on the line or not.
Are you there, Delegate Converse Fowler?
Yes, Mr. Chairman, here.
Okay, fine. What did we do with your bill last time?
I believe it was PBI and reconsider.
Is there a motion to reconsider we've already done that. All right, so it's back on. All right, and you would like to have the bill PBI'd and re-referred to Boyd Graves, is that right? Okay.
Yes, sure.
Motion to PBI the bill and refer it to the Boyd Graves Conference. Senator Saslaw makes that motion. Senator Deeds seconds it. All in favor of the motion to PBI the bill with a letter to the Boyd Graves Conference. All in favor, vote aye. All opposed, no. Yeah, okay. Yeah, they're gonna be busy. Okay.
Ayes 14, noes 1. Senator Stanley should be in the, I'll make that correction.
Yeah, make him twist him a little bit. Okay, anyway, it's been PBI'd, and thank you very much, Delegate Converse Fowler. Okay, what next? We go down the list here. 2291 Williams Graves, House Bill 2291.
Yes, sir. I am here.
Okay. Tell us about your bill, 2291.
Thank you so much, Mr. Chair and members of the Senate Committee. House Bill 2291 acts to include the Sheriff's Deputy's Office as it, excuse me, as it pertains to oversight for a community oversight board in its day-to-day operations. This bill is very similar to a bill that was passed last year that included, that provided for oversight for police officers. And so this bill just simply comes back to add sheriff's deputies. The bill has had some amendments to it on the House side, which make the recommendations from the Oversight Committee, the Community Oversight Committee, a process by which the Sheriff's Office is not required to they're not required to accept the recommendations of the committee, but if they should not implement the recommendations of the committee, then they would be required to submit a public statement or make a statement available to the public as to why they are not accepting and implementing the recommendations of the committee. The bill is supported by the NAACP, the ACLU, and several other criminal justice organizations. And I move that the bill be accepted and report.
Okay,
please.
well, that's up to the committee.
Mr. Chair.
First of all, I think the reason they were not included in the optional civilian review panels at the local level is because they're independently elected. They're not part of the police department. And the second thing is they are, because they're independently elected, they're accountable to the people directly because of that. Senator Deeds.
I was just going to ask, doesn't this amend something we did this past summer? And didn't we at that time intentionally exclude sheriff's deputies for exactly that reason?
That's exactly right.
Mr. Chairman.
Okay, Delegate
Senator Servo.
Senator Servo.
No, Mr. Chairman, Senator Deeds' recollection is accurate. This was actually a bone of contention between the House and the Senate, and we reconciled it by accepting the legislation that we passed, which I don't believe has even gone into effect yet. But I would also just note, Mr. Chairman, that my recollection of what happened is that the sheriffs were going to come back to us with some sort of proposal to provide them with independent oversight. I have yet to see that proposal. Okay. So if we're going to take testimony, I'd like to hear when the sheriffs are going to make that proposal, because if not, we're going to have to figure out our own sooner or later.
Yeah, we have limited time here too, and the other bill hasn't even gone into effect yet, I don't believe.
Mr. Chair.
Yeah, Senator Peterson.
Mr. Chair.
Senator Peterson, go ahead.
I'll defer to the delegate.
Yeah, go ahead, Delegate.
All I was going to say is that I understand that compromise from the previous year. And while I have had some conversations with the Sheriff's Association, what I have not received is any type of proposal, if you will, with regard to this. There were the amendments that we have put forward and that were accepted in the House were based on objections that were made, some by the Sheriff's Office. And then there is an amendment that the Clerk's Office should have for you that kind of clears up some language on line 27 with regard to adding some clarifying language, but we have not, my office has not received any proposal.
Well, let me ask you this. Is anybody from the sheriff's office representing the sheriffs here? John Jones?
Yes, sir, Mr. Chairman.
Yeah, go ahead. What is your position on this?
Good afternoon, Mr. Chairman and members of the committee. I'm representing 118 of the 123 sheriffs. The Virginia Sheriff's Association unanimously opposes this bill on a number of issues. But let me address the question that was raised by Senator Serval. We worked with the members of the House and Senate during the special session in the summer, and the representation was that the sheriff would put together a committee, we would look at it and come back and try to come up with something that would try to address oversight. In the meantime, and during the special session, the House and Senate passed Senator Lucas's bill, which provides that the Attorney General can initiate an investigation at any time if there's a concern of a civil violation in a sheriff's office. We felt like that, combined with the situation of a sheriff's office, a sheriff being a locally elected constitutional officer, that is about the best citizen review board that you'll get. So under the bill, the local governing body would appoint a committee to oversee the sheriff's office. That is not going to be a good fit with the sheriff, because what we'll end up with are candidates for sheriff getting on this committee, or people, that were defeated for sheriff getting on the committee. So we don't think it's a good fit. We don't see how it can work with a constitutional officer. And I would also point out that, the chiefs have this, but the bill hasn't even gone into effect yet to see how it will work for the police department. So we're very much opposed to the bill. We hope you'll defeat it.
Mr. Chair.
Senator Peterson's next in the queue.
All right, and I know Senator McClellan wants to, I'll just get right to the point. We spent all summer on criminal justice reform, and we specifically rejected this idea about having sheriffs subject to a civil review panel for the very simple reason that they're constitutional officers, and frankly, they're of equal dignity to us, and they're up for re-election every 4 years, and so they can be defeated if they don't represent the community. So, with all due respect to the patron, I'd move to PBI.
Okay, Senator McClellan wants to speak next.
I do. I want to set the record straight a little bit as someone who was part of the discussions with the sheriffs over the summer. And part of the discussions that took the sheriffs out of the purview of the civilian review bill overall. With all due respect, that is not what we discussed, that the AG's office would be the appropriate civilian review. As a matter of fact, we expressly in those discussions said it is not going to be good enough just to say the sheriff is up for re-election, to say that is the only oversight over every employee in the sheriff's office. And we asked the sheriffs to come back with a proposal. And now to hear that their proposal is, well, you've already passed something saying the Attorney General can look into it. The Attorney General is not civilian oversight. And so I'm very disappointed to hear now that there's not going to be any discussion about what civilian oversight there could be over sheriff deputies and sheriff employees.
Mr. Chair.
It may not be this bill, but the sheriff being elected every 4 years is not enough, given some, if you have a sheriff's deputy or a sheriff's employee who engages in some of the activities that prompted the Civilian Review Board bill to begin with, many of the people who are impacted by that behavior can't vote.
Okay.
Mr. Chair.
Senator Peterson, we need to kind of wrap this up.
I realize
I don't
that,
want to cut the Williams-Graves speakers off, but
well, I think it's worth
Senator
responding
Peterson,
to just one point. The Civilian Review Panel passed on a 21-19 party line vote. 21-19. And that's with sheriff taken out. You left it in, you may have had 8 or 10 votes.
Okay.
So that was how we got it passed. And I may not have everyone in our caucus happy, but that's how it passed.
Okay, again, I don't want to leave any of our speakers out, Delegate Williams-Graves, but we need to move it right along. It doesn't look like this bill's going anywhere. Yeah, Senator Serval.
Thank you. The only thing I want to say, Mr. Chairman, is I completely concur with what Senator McClellan said, and I just want to make clear that we need a proposal. And if we don't get a proposal, then something like this is going to pass next session or soon thereafter, because I thought we were promised some kind of proposal, and I'm really disappointed to hear that Senator Lucas's bill had something to do with this discussion, because I don't remember it that way at all.
Is there a motion, again?
I want to say,
Mr. Edward,
Senator Peterson.
Mr. Chair.
The patron wants to say something. Williams Graves, go ahead.
Mr. Chair, thank you. I would like to make 2 points. One is that this bill is solely permissible, and it gives the opportunity for it. It is not a has to do it. It's a may do it, and it gives the opportunity for the sheriff's office to reject those recommendations that are made by the Civilian Review Board. The second thing that I would also like to point out to this body is that and it goes to Senator McClellan's point, the sheriff election is one person's election. And while the sheriff does have within his or her purview to come in and fire his or her entire staff because they work at the will of the elected sheriff, that is not likely to happen. And so the culture is not likely to change because one person may or may not be elected. And when it comes to the placement of individuals in those civilian review boards, we have worked very hard to appoint people all across the state to various boards and commissions. Some of them may run against us, but if we are doing the job that we're elected to do, the people will see that and they will vote for us and they will reelect us because we are doing our job. So that is the reason why I reject those particular arguments that come from the Sheriff's Association, with all due respect to the Sheriff's Association and to its chair.
Okay, is there a motion? We kind of need to move along. Okay, the motion is to what? PBI the bill from Senator Peterson and seconded by Senator Deeds, is that right? Okay, all in favor of the motion to PBI the bill, vote aye. All opposed, no.
Ayes 12, noes 2, 1 abstention.
Okay, 12 to 2 and 1. Okay, thank you, Delegate Williams Graves. We appreciate it very much. All right, Senator Health
Thanks,
Bill
sir.
1853, Delegate Sullivan. Delegate Sullivan.
I'm here, Mr. Chairman. Thank you very much.
1853, lawyer-client accounts.
Mr. Chairman, I was with the committee just a couple of days ago on 1853, so I don't want to tread on the committee's time to explain it again, just simply generally remind people that this is the bill that repeals the prohibition for the Supreme Court to consider mandatory IOLTA accounts for lawyers in Virginia. The committee put me over so that a couple questions could be answered from some members of the committee. I'm prepared to answer those. I know Mr. Benjamin, Senator Stewart, and Senator Peterson have heard from, at least, and in some cases have spoken with, Mark Braley, of course, who runs the Legal Services Corporation of Virginia, with answers to the questions, hopefully satisfactory answer to those questions. I'm happy to go through them, Mr. Chairman, if you'd like.
Just don't repeat it, but anybody have any questions of Delegate Sullivan on 1853 having to do with lawyers' trust accounts? All this does is allow the Supreme Court to come up with some rules on this.
Mr. Chairman.
Yeah, Senator Obenshain.
Yeah, and I'm carrying Senator Stewart's proxy, and the last thing he said to me as he was leaving it was he would support this bill only if it imposed the obligation on the banks, not on the lawyers. So I don't know whether that indicates that his questions were answered or not, but without an amendment to do that, I can't cast his vote for it.
Sure, okay. Anybody else have any questions of Delegate Sullivan? Okay, if no further questions? All right, is there anybody ready? Is there a motion on 1853?
Chair, we do have one speaker.
Okay, who's that?
Matt Bruning.
Okay, Matt, go ahead. The
Yeah,
banker.
good afternoon, Mr. Chairman, members of the committee. Happy to answer any questions, but right now the bank already does the computation and the direct remittance of the interest to legal services. So I'm not sure what Senator Stewart and he and I had some communications, but I'm not sure what else other responsibilities he would like to shift to.
Okay, Senator Peterson, he has a question.
Matt, I have one question, and that is, to the extent interest is charged on the IOLTA account, it does not actually accrue to the IOLTA account, so it won't mess up all my client accounts. You all just scrape it off and pay it to legal aid, correct?
Correct.
Mr. Chairman, Senator Peterson, as Delegate Sullivan said, that is correct.
Because I will come find you.
To legal services.
I will come
That is
find you.
correct.
Okay.
You know how to find me, Senator.
Any other questions? Is there a motion? Moved and seconded to report House Bill 1853. It does not need an amendment. Okay, all in favor of the motion to report 1853, vote aye. All opposed, no.
Ayes 9, noes 5.
9 to 5, the bill is reported. Congratulations, Delegate Sullivan. House
Thank
Bill
you, Mr. Chairman, members of the committee.
1951, Delegate Simon.
Yes, Mr. Chairman, members of the subcommittee, I don't know if we're ready to finish 2276 first, or if you want to just go on to 1951.
I don't know where we are with 2276. Where's Searle? Okay, he's still working. All right,
Okay.
House Bill 1951, Delegate Simon.
So, Mr. Chairman, members of the committee, this bill is one that will be familiar to you, and I'm going to try and come at it from a little bit of a different angle because I understand you guys had some questions about this bill last year, and hopefully I can address some of those issues for you.
Okay.
HB 1951 eliminates the common law crime of suicide. As you all probably know, Virginia in Section 1 imports all of the British common law into our code unless it's contrary to the code and so forth.
Right.
And so, as a result, we've got Creed looks like he's losing. The Delegate Deeds looks like he's, or Senator Deeds losing patience with me already, and I'm just getting into it.
Well, let me ask you this. What about assisted suicide?
So this has nothing to do with assisted suicide.
Well,
It has everything to do with
But
it.
if it's no longer a crime, there's no crime of assisting
Right.
somebody to commit suicide.
So, Mr. Chairman,
Mr. Chair.
Mr. Chair, I think this is referring to people's families who leave the memory of their children. Yeah.
They're never, all right.
Okay. Any other questions?
Mr. Chair,
Yes, Senator Peterson.
I feel like we've had this discussion
We
for
have.
a generation.
We have.
And no one's charged with suicide. It's not a crime in Virginia. But what you do is if you repeal this, then you make it possible for people to assist a suicide and not be charged, because basically it's a non-criminal act at that point, so they could be an accomplice or assist with it, and they would be given a free ticket. It would be completely legally immunized. So
Doesn't it also, Delegate Simon, affect law enforcement? They may need to come in and check what happened.
right, they wouldn't be allowed to. They couldn't stop it.
Mr. Chairman, member, and Senator Serval. So, Senator Peterson, excuse me. So it's interesting. Law enforcement actually already treats so under 15.2, 1722. They do have to keep records of suicides. They do have to investigate any unattended deaths, including drug overdoses and so forth. So that's already there. In fact, in 15.2, 1722, we actually list suicide records as non-criminal incident records. So interestingly, we already treat them as far as record keeping by police officers as non-criminal incidents.
Right.
So
what's the point?
What's the point?
So we have a number of witnesses who'd be happy to much more accurately describe the point of it.
Yeah, how many witnesses? And we don't have so much time again.
We have 3 speakers.
I'm very sympathetic to anybody whose family has suffered this, and my family has too, by the way. 5 or 6 years ago, a very prominent doctor, cousin of mine, committed suicide. He was very depressed. We understand what happens, and we're very sympathetic to that. All right, if you'd like to have a few people speak very briefly.
Bethany Harrison, please go ahead.
Thank you, Mr. Chairman. My name is Bethany Harrison, a Commonwealth's attorney for the city of Lynchburg, speaking on behalf of VACA to the bill. The senators have raised many of the same issues that we have. We're not supporting or opposing the idea of abolishing common law suicide. Our concern is currently with the law enforcement officers may obtain search warrants for crime scenes, or it could be a crime scene that appears to be a suicide, and without a mechanism that allows the officer they can currently get a search warrant now where there's probable cause for suicide. We don't want there to be a homicide stage of the suicide. They're not able to.
So you oppose the bill?
Investigation.
You oppose the bill?
Well, if there's a provision that allows for there to be search warrants or investigations, which I believe last year there was a provision for that, and that was not included this year.
Okay. So you're against the bill?
One abolish.
As the bill stands, you're against it or for it?
If there's no provision that allows for further investigation, then.
So you're against it?
Yes.
Okay, next.
Sharon Webster, please go ahead.
I don't know, three speakers.
This is getting to be ridiculous. Common law criminal, the label is being used, and basically it's on the books as a law, as a label. And as someone who has struggled and died as a result of suicide should not be called common law criminal any more than someone that has had a heart attack or someone who has diabetes and died by diabetes. I'm just to the point of giving up on this group.
I don't disagree with you on that. They should not be considered criminals. I agree. But next.
But that's the label, Senator.
Well, okay. Go ahead.
K. Rob Krupika, please go ahead.
Good evening, everybody. I'm going to make this really brief. I think I listened to the Senate all day today, and I hear a lot of comments about making sure our definitions are right. And I think this is a question of whether or not the definition is right. Suicide, by all medical science and mental health professionals and everyone else, is a mental illness. It is not a crime. Yet our definitions in our code would imply that suicide is a crime. Now, I hear the comments about assisted suicide. I don't believe this is meant to have anything to do with that. And I would argue, as I've heard when I was in the General Assembly, if you are worried about assisted suicide, get a bill for assisted suicide.
Okay.
Mr. Chair.
We appreciate your front. Yes, Senator Peterson, got a motion or something?
Yeah, I do. And I've heard Senator Krupika, and when he was in the House, he always brought this bill. The bottom line is we don't define suicide as a crime in Virginia, so there's nothing to repeal. What we would do by passing a bill like this is basically immunize the assisting of suicide, which would be a terrible mistake. So I move to PBI.
Is there a second? We've got a motion to PBI the bill made and seconded. Is there a substitute motion? Okay. So substitute motion to report the bill. Senator Chasslaw says, is there a second to that? Second. Okay. Substitute motion. All in favor of the motion to report the bill, vote aye. All opposed to the bill, vote no. Yeah, this is a report. If you like the bill, vote aye. If you don't, vote no.
Ayes 5, noes 10.
Okay, thank you. 5 to 10, the bill is not reported. Thank you all very, very much. Okay, House Bill 1991, Delegate Jones.
Yeah, good afternoon, Mr. Chairman, members of the committee. We brought House Bill 1991 back from last week, worked on it a little bit, and I do believe that there were some technical amendments we made last week. I want to make sure that those are still before the committee. We inserted and commitment order after each instance of plea agreement. But to refresh everyone's memory, the bill clarifies that no matter what any plea agreement says, courts that sentence juvenile serious offenders must hold a meaningful review after the juvenile has been in bon air for 2 years. Even though these hearings are already statutorily required, children across the Commonwealth are entering into plea agreements that attempt to limit DJJ's ability to petition for this review hearing, the court's ability to hold the hearing, or the court's ability to modify the youth sentence at the hearing. I want to make very clear, though, this does not say that the court has to change or modify or do anything to the sentence. We just want the child to have that hearing that they're statutorily entitled to.
Okay. Any questions of Delegate Jones and House Bill 1991? Do you have anybody speaking in favor of the bill?
We do have a couple of people, Senator Edwards.
Yes. Yeah, keep it brief, okay? Thank you.
Sure.
Bethany Harrison, please go ahead.
I'm speaking in opposition to the bill. Do you want me to go ahead and speak?
Yeah, go ahead.
Okay. Thank you, Chairman Edwards. Bethany Harrison, Commonwealth Attorney for the City of Lynchburg. Here on behalf of VACA, we are opposed to House Bill 1991. As Delegate Jones stated, these hearings are already statutorily required. The language of this bill says that even despite a plea agreement, that we have these hearings. I guess we just don't see this as necessary. as well as when we are entering into these plea agreements, we know more than the judge knows at that time, and we're entering into these agreements for a reason. So for those reasons, we are opposed to this bill.
Mr. Chair, can I ask you?
Yeah, so Delegate Senator Creed.
Ms. Harrison, is it your view then that the Commonwealth can negotiate this statutory right away, the right away to have the hearing?
Well, currently the statute requires that for the judge to make a decision in the initial order to state the period of commitment. And this provision would say that if there's an agreement ahead of time that the child will be committed under serious offender for a term of years, you still can have your reviews, and the court could still make a decision at that time about that. But
so you're,
yes, I mean, you can negotiate these things. A knowing and voluntary plea agreement. Yes, you can.
Thank you.
Delegate Deeds. Okay. Anybody else? Do you have anybody, Delegate Jones, to speak in favor of the bill?
Delegate Jones.
Senator, we have the Legal Aid Justice Center and Director
Okay.
Boykin from
There's
BJJ is also
there's-
here to answer any questions.
There's some amendments. Is that right? Are there some amendments?
There were technical amendments made last week.
Okay, we've already taken.
Mr. Chair, because
Go ahead. Yeah. Who's speaking?
right, because the bill got passed, by, the amendments were never adopted.
Okay, is there a motion to adopt the amendments? Motion to adopt the amendments. Delegate Senator Deeds moves the amendments. It's been seconded. All in favor of the amendments, vote aye. Aye. All opposed, no. The motion carries. The bill with amendments. Delegate Jones, did you have anybody else you want to have to speak in favor of the bill? Remember we did.
Yeah, Julie McConnell,
discuss it.
Senator Edwards is in
Okay,
the room.
Julie McConnell. Okay.
Good evening, everyone. My name is Julie McConnell. I'm a law professor at the University of Richmond Law School. I've done probably 60 or 70 of these serious offender cases, both as a prosecutor and a defense attorney. And the issue is that when young people enter into these plea agreements where they know they will have a serious offender review in 2 years, and then every year thereafter until they're 21 or until the judge releases them, they have an incentive to take advantage of the opportunities at the Department of Juvenile Justice to rehabilitate themselves, get an education, and really work on their reentry. DJJ is doing incredible work to prepare young people for release. And what happens is we go into these hearings, and oftentimes the prosecutor will say, we have a plea agreement in this case, so this hearing is meaningless. The judge can't do anything to reduce the sentence in spite of what the statute says because there was a plea agreement. And our argument is that the plea agreement included a serious offender commitment, therefore a statutory review of that commitment, at which time the judge could use his discretion or her discretion to reduce the sentence. What we are running into is that sometimes judges agree that because there was a plea agreement that they can't do anything, that their hands are tied and they're not able to suspend any of this time at the review. Okay. Of course, the law actually is not on that point. The law actually says that you can consider these sentences again at the review, but some kids are being denied the opportunity to get released early when they have been rehabilitated because of this argument that plea agreements are binding.
Okay, thank you very much. I think we heard it before too. Anybody else, Delegate Jones?
Do you guys have any questions? Valerie Boykin, Director of Juvenile Justice, is also here.
Okay, go ahead, Valerie.
Good evening, Mr. Chair, members of the committee. The department offered no official opinion on this bill. However, I'm here to answer any questions. Our position has been that we will file the petitions as required by code.
Okay. Anybody else feel the need to say anything? I think we understand the bill. Is there a motion?
Move to report.
Moved and seconded to report the bill as amended. All in favor of the motion, vote aye. All opposed, vote no.
Ayes 9, noes 4, 1 abstention.
Ayes 9, no 4, 1 abstention. The bill is reported as amended. Thank you very much, Delegate Jones. Appreciate it.
Thank you.
And everybody else who had anything to say about the matter. Okay, where are we, Serval, Delegate Serval?
Mr. Chair, I do have the amendments to House Bill 2276, Delegate Simon's ghost gun bill, if you want to take that. Yeah.
Okay, let's do that. Delegate Simon, 2276, with amendment. What are the amendments?
I am back and I understand that Charles has got some amendments that'll take out the possession issue, which would mean that somebody already has it, made it 5 years ago, and they still have it, they can keep it. They just can't sell it, transport it, try and use it and so forth.
And
Right.
there is a process to get a serial number from a dealer, is that right?
Right. So in the meantime, while they're waiting, they can get their serial number, but they're not felons in the meantime, as the gentleman from the NRA suggested.
Okay, so, all right. Okay.
So the amendments, Mr. Chair, would be on line 41. It would be strike possess, transport, or receive, and we would insert or before purchase. We would strike possession or on line 42. So essentially that sentence would read, it is unlawful for any person to sell, offer to sell, transfer, or purchase any any unfinished frame or receiver unless the party receiving the unfinished frame or receiver is a federal firearms importer, etc. Okay. And then similar amendments on lines 50 and 53, striking possess, transport, or receive, and then striking possession or on lines 53.
Okay,
Second.
moved and seconded that the amendments be adopted. All in favor of the amendment say aye. Aye. All opposed, no. The bill is amended. It's been moved and seconded that the bill be reported as House Bill 2276. And bill be reported as amended and re-referred to finance. All in favor of reporting and re-referring the amended bill 2276, vote aye. All opposed, vote no.
Ayes 6, no 6, one abstention.
6 to 1. There's some people still that haven't voted too, but anyway, all right, 6, and 1. The bill is not reported by a vote of 6, and 1.
Having voted on the prevailing side by which that bill just failed, I move we reconsider.
All right, it's been moved and Senator seconded that the bill be reconsidered. All in favor of the motion say aye. Aye. No, you got to vote. You got to vote to reconsider. Vote aye. Or vote. Okay, opposed. Vote no. Okay. Bill is reconsidered. Now where are we? Bill has been reconsidered. Senate Bill 2276 as amended. Been moved and seconded. That's a bill.
All right, Mr. Chair.
Yes, Senator Peterson.
Yeah, I abstained. I'm going to go ahead and vote green on this, but I still think this bill needs more work. I think, again, you've got people with legal protections that need to be respected, but just to move the process along, I'll go from yellow to green at this point.
Okay, it's been moved and seconded. Enough. Okay, been moved and seconded that the bill as amended be reported. All in favor vote aye. All opposed vote no.
Ayes 8, no 6.
8 to 6. The bill is reported 8 to 6. Okay. Thank you very much, Delegate Simon. All right.
Thank you, Mr. Chairman, members of the committee. I appreciate your time.
Okay. Now, Delegate Simon, you have a couple of those, don't you?
No, I think those were the two that I have. I think Delegate Scott has a couple more.
Scott. Okay. All right. Let's see, where should we go from now? Guzman 2139. Where are we with that?
I'm here, Mr. Chairman.
Okay. 21, let's see, 2139. Okay. Okay, this is accrual of a cause of action. Okay. Diagnosis of latent injury. Okay. Mr. Bob Patton is here as well. This has been reconsidered, so is there a motion on the amendment? Did everybody have the amendment?
Mr. Chairman, the
Yes.
substitute has been posted to LIS.
Okay, the substitute has been posted. Is there a motion to adopt the substitute? Senator Deeds moves to adopt the substitute. Senator Boysko seconds it. All in favor of the motion to adopt the substitute, say aye. Aye. All opposed, no. Okay, the bill is fixed, I think. So would you like to, Bob Hatton, would you like to explain it?
Move to report, Mr. Chairman.
Wait a minute, just a second.
We've heard this bill for hours.
Okay. Okay, does everybody understand the bill? All right. All in favor of the substitute to House Bill 2139, vote aye. All opposed, no.
It's 10 noes, 4.
10-4. Okay, congratulations. The bill is reported, the substitute is reported.
Thank you, Mr. Chairman,
Okay,
members of the
thank you
committee.
very much, and thank you for sticking around. Okay, Delegate Lethwich, 2102. I'm just going down the list here.
I'm here, Mr. Chairman.
Okay. Where were we with 2102? Can't remember. House Bill 2192, I'm sorry.
Yes, sir.
Okay.
So essentially, what this bill does is when, in a child support matter,
Yeah.
when a court enters an order, there are certain requirements that the order must contain. And so what this bill does is it requires the parties to inform the other party and the Division of Child Support Enforcement if they receive unemployment compensation.
Right. Okay.
The reason for that, I'm sorry, well, go ahead. The reason for that is because you cannot issue a subpoena to take them against the Unemployment Commission.
Yes.
There's, during the federal law, they're not allowed to disclose that information. So what this does is it gives the parties an opportunity to know that that's the situation, and if necessary, file discovery and or go to court and get an order requiring the information to be submitted so they can adjust support accordingly.
Okay. All right, do you have anybody speak in favor or anybody against the bill?
No, sir.
Okay, is there a motion? We don't need it amended either, right? Okay, is there a motion to report House Bill 2192? Is there a motion? All right, been moved, and Senator Deeds seconds the motion to report Senate Bill 2192. All in favor vote aye, all opposed vote no.
It's 14 noes, 0.
Okay, good. All right, we've got House Bill 2234, Delegate Brewer.
Hello, Mr. Chairman. Are you ready for me to proceed?
Yeah, go ahead. Victim sex trafficking, 2234, Delegate Brewer.
Thank you, Mr. Chair. House Bill 2234 actually came before this committee last year, and we just got to the end of session where we're not able to address it. What this bill actually does is it allows for affirmative defense for victims of human trafficking. We did some considerable work in courts last year to narrowly tailor the bill, and so I hope it'd be the pleasure of this committee to report the bill.
We got it fixed last year, didn't we? Okay.
Yes, sir.
Yeah. Anybody want any questions? Anybody here to speak for the bill or against the bill? All right.
Yes, sir, Mr. Chairman.
Yeah, go ahead.
Thank you. My name is Tom Antorcio, and I'm an associate director with the Virginia Catholic Conference. We strongly support the bill. In the interest of time, I'll just say that the National Conference of State Legislatures has noted that the majority of states, including Maryland, do enable for traffic victims to assert an affirmative defense. Thank you so much.
Thank you. Anybody else need to say anything?
Patrick McKenna, please go ahead.
Patrick, go ahead.
Yes, thank you, Mr. Chair and members of the committee. Patrick McKenna, Virginia Coalition Against Human Trafficking. We support this bill. While we'd like the charges that are included to be expanded, we are grateful for this step forward on behalf of survivors of trafficking.
Good.
Thank you.
Thank you. Anybody else want to speak for the bill?
One more speaker, Mr. Chair.
Okay.
Jonathan Iglesias, please go ahead.
Yes, hello, Mr. Chairman and members of the committee. Jonathan Iglesias with the Virginia Sexual and Domestic Violence Action Alliance. We support the bill and thank the delegate for carrying it.
Okay, thank you very much. Anybody else?
Not at this time.
Anybody against the bill?
Mr. Chair, I've got a question for staff.
Go ahead. Senator Deeds.
On line 13, victim of sex trafficking, could that include, is that broad enough to include someone who bought sex?
Mr. Chair?
Yeah, go ahead.
I can respond.
I'm asking staff right now.
Okay, staff. Anybody have any answer to that question? You understand the question?
Go ahead, Charles, if you have an answer.
Yeah, Charles?
Mr. Chair, I do think it is broad enough to include people who would be on the purchasing end.
Okay.
Is that your intent? I'd ask the delegate, was that your intent?
My intent, Mr. Chair, Senator Edwards, my intent was only to include narrowly tailored, which are the charges 18.2, 346, and 347. So I believe that was able to narrowly tailor the bill.
Charles, Mr. Chair, if I could ask Charles, well, if she's talking about only people that violate 346 or 347, does that include people who buy sex?
Yes, Mr. Chair. The problem is within section 18.2, 346, subsection B, it includes people who purchase sex. So the definition would need to be amended to exclude those people.
Well, do you have some amendments that would could you suggest some amendments that would fit what she's trying to do?
Mr. Chair, I probably can find some amendments. I believe if you insert, and let me find the right line number for it. If you were to insert, essentially, I may need a minute just to make sure I have the right amendment, Mr. Chair. But I could come up with something if you want to pass it by temporarily.
Okay, Cree, you want to?
Yes, Mr. Chair. I don't mean the bill any harm. I'm just afraid that definitionally it's too broad and it catches accidentally perhaps people who are victimizers, not necessarily victims of these sorts of offenses.
Well, Mr. Chair.
Can we fix that on the floor?
Yeah.
Mr. Chairman,
yes,
Senator
Steve,
yeah,
go ahead. Go ahead.
Senator Dietz is absolutely correct. The way the bill is worded, the category of person we refer to as a John could be defined as a victim of sex trafficking if he were solicited, if the other person suggested to him that they would have sex with him if he paid, then because he would have been solicited under this definition, he would be considered a victim of sex trafficking, and I know that is not the patron's intent.
Mr. Chair.
Yeah, Senator McClellan.
But, Mr. Chair, but how likely would it be that he would be eligible for the affirmative defense in that he was coerced to engage in the offense through the use of force of intimidation of another? The offense was committed as part of a commercial sex trafficking scheme, or the offense was committed at the. Oh, that's an or. Okay.
Yeah, this or.
Yeah. Yes. Steve.
I think Senator McClellan caught it. There's an or there, and so if he could use the affirmative defense, if the offense were committed as part of a commercial sex trafficking scheme, which is not defined. Each act of prostitution is a commercial sex trafficking scheme. So yeah, that inadvertently, because again, I know it's not the patron's intent here, but this bill as written does provide an affirmative defense to someone we don't want to have one.
Mr. Chair?
Yeah, Delegates Simon, who's this?
That's Senator Peake back here.
Yeah, Senator Peake.
I would move to report the bill, and that this is one that we can fix that problem. We've been doing whole bills on the floor all session. I think we can come up with a couple lines to fix this on the floor.
Senator Chair, if I can ask Charles or Steve, is that workable? Can you get me amendments by the time this gets to the floor?
Mr. Chair, I would feel pretty confident that I could get you some amendments to fix it.
Okay.
The issue of the person, the John included as a victim.
Let's not use the word John.
And I would just say, Mr. Chair, to Delegate Brewer, that we mean no ill will towards your bill. I'm just trying to make sure the definition is narrow.
Okay.
Mr. Chair.
Yeah, Senator Morrissey.
Can I ask either council a question?
Either one, go ahead.
Okay. Charles or Steve, right now, if an individual is charged with prostitution, is she not allowed to say, yes,
Jennifer, you're shaking your head. If I can just ask the question.
Go ahead. I'm listening.
Isn't it true that a defendant who's charged with prostitution could say, yes, I engaged in prostitution. However, I did it because it was under duress. I am the victim of sex trafficking. Is that defendant allowed to say that now in court without this legislation?
Mr. Chairman, Senator Morrissey, you can certainly try to. I don't know if it would be successful. I don't know if it would be permitted. The extent to which duress is permitted as a defense is fairly limited.
It is very
Mr.
much.
Chair.
It's a good question, but
Yeah,
not confident the answer.
Senator McClellan.
Mr. Chair, and the reason, and Senator Morrissey, I anticipated your question because this is an issue that we've been trying to fix for a very long time.
We've had a bill on that.
And when it is a fact that many, mostly girls, who have been arrested for prostitution have tried that defense and it hasn't worked because the courts have found duress is if you have a gun to your head or you are threatened with immediate bodily injury, that would count.
Right.
But that's not usually what happens in human trafficking. There's a very long process of grooming where you are brought in as part of a quote-unquote family and you are threatened with not immediate harm, but longer term or being ostracized from the family. And so, unfortunately, very rarely does that defense work.
Okay.
Mr. Chairman?
Yeah, Senator Morrissey, real quickly, we need to move on. Go ahead.
I have already accepted and buy in 100% to the notion that these women who engage in it are victims of sex trafficking. Full stop. I'm already bought into that. My question is, there's a difference between raising a defense and versus the judge or fact finder saying, I don't accept it. I asked a very specific question. Is a victim, say a woman who stands up and says, I am a victim of sex trafficking, allowed to make that defense? Mr. Benjamin said, it's questionable, perhaps not. I need to do my own homework on that, but I'd like to know an affirmative answer to that before this comes up on the floor. So the issue for me is not whether these people are victims. I understand that.
Okay.
The question is whether or not they can make that defense. That's
Okay. And Charles is going to get an amendment to the floor too, right? Are you ready to move forward with the bill? Yeah. Okay. Is there a motion to report the bill? Okay. Is there a second? Senator Deeds seconded. All in favor of the motion to report the bill, vote aye. All opposed, no. Vote is, what's the vote?
It's 14-0.
14-0. The bill is reported, and we'll look forward to getting an amendment on the floor. Okay. Thank you very much.
Mr. Chair, members of the committee.
Yeah, congratulations. House Bill 2254, Delegate Corvers Fowler. And this has to do with unlawful dissemination of unsolicited, obscene image of self to another penalty. Okay? Delegate Corvers Fowler, go ahead.
Yes, Mr. Chair, I believe there is a substitute.
Okay.
Yes, Mr. Chair, the substitute has been posted to LIS.
All right, tell us what it says. Okay, Senator Deeds moves to adopt the substitute. Senator Sherrill seconded. All in favor of the motion to adopt the substitute, say aye. Aye. All opposed, no. Substitute is adopted. Okay, explain it to us.
Thank you, Mr. Chair. This substitute removes the element of harassment from the bill. So this bill, HB 2254, is a bill that would make it illegal to send pictures of one's genitals to another without their consent. In 2017, they found that 53% of millennial women had received an unsolicited picture of someone's penis. This picture or video, these pictures and videos are disseminated or transmitted via text, direct message, email, or even airdropped in public places. So it can just show up on your phone. without any warning. I work in real estate, and and many real estate agents have very public cell phone numbers. In the last year, many agents have become victims of this cyber flashing. Maybe the pandemic has people bored, but regardless, we quickly found that there was no recourse for this offense. Last week, some realtors actually were on a Zoom, and a random visitor that was engaging in a sex act wasn't discovered for several minutes by the presenter. Sending someone an obscene picture should require consent from the recipient. Sending an obscene picture to someone without consent is the equivalent to cyber flashing. Indecent exposure is a similar offense, and main difference would be that indecent exposure is done in person. The penalty for this would be the same, a class 1 misdemeanor. And Mr. Chair, I thank you, and I hope the entire committee agrees that we need to ban cyber flashing.
Okay, anybody want to speak in favor or against the bill?
At this time, we have no speakers. Mr.
Okay,
Chairman.
is there a motion?
Mr. Chairman, I have a question.
Yeah, go ahead. Senator Sherrill.
First of all, I have no idea who likes or enjoys or gets off doing this, but I guess there's people out there that do. But what I suppose, like a boyfriend, I guess boyfriends and girlfriends do this. I mean, I started dating before these phones existed, so this wasn't a thing back when I used to date. But in any event, how do you differentiate between a consensual one of these and one that's not consensual? For example, I could see a situation where boyfriends and girlfriends are trading pictures of themselves, and the relationship goes bad, and then a week or 2 or 3 later, somebody's swearing out a warrant saying, hey, he keeps sending me this or she keeps sending me that, and now there's misdemeanor charges and lawyers involved. So how do you differentiate in a situation where the people had a relationship at one point?
Mr. Chair, is that?
You go ahead. Yeah. Delegate.
Thank you, Mr. Chair. The wording with a consent and unsolicited, we worked on. In Texas, they have express consent, and that could be an amendment that would be helpful if the committee so chooses. But right now, consent would be deemed as how consent is in other parts of the code.
Yeah. Okay. All right, anybody else?
I've got a couple questions, Mr. Chair.
Yeah, go ahead, Senator Morrissey.
Okay. I've struggled over this bill, and I've read it many times, and I'm having a very hard time. Tell me in simple language how the Commonwealth would prove the mens rea component, the intent to coerce, harass, or intimidate, if this were done. If you can just answer that first question.
Charles.
I think Senator Morrissey's looking at the bills that came over from the House and not the substitute version.
Okay.
I don't want to speak negative about the bill, but this bill does not actually have a mens rea component to it, which I do think is.
Well, do you have an amendment or anything like that? Any amendments to fix it?
No.
Mr. Chair, I am not quite certain how to fix it, putting some sort of mens rea component back into the bill.
How about intentional?
Right now, it's essentially a strict liability for anyone who transmits any still image of any person engaging in sexual conduct or any person with genitals exposed. I don't want to make too big of a point of this, but that would also include essentially a photo of a work in the Met of, a work of art, so to, a true work of art that depicts a person with their.
Well, can you come up with an amendment?
Hold on, Mr. Chair.
Go ahead. Steve, I'm listening. Go ahead.
Chairman,
Charles, go ahead.
Jesus.
And that's what I'm trying to say. I don't know how to come up with an amendment when
Mr. Chair.
Commercial speech would be protected.
Mr. Chair.
Issues
Let Charles finish.
I think
go
I
ahead.
still
Charles,
had
go
the
ahead.
floor.
Charles, go
that's
ahead.
all I have to say is
Okay.
I think the bill has a lot of First Amendment problems, and I'm uncertain how to get around those problems.
Okay.
I have a
Hearing
motion.
what the
Can I
major
make
has
a
to
point?
say.
Just a minute. Yeah, Senator Morrissey.
Thank you. Charles made the most important statement a few moments ago when he said, this bill as currently written imposes strict liability. So here's the situation. When boyfriend and girlfriend are on good terms, the picture that is sent is good. That's okay, even though it's a violation of the law. 2 weeks later, it's if you impose a strict liability standard, the person has now committed a crime. That's the first problem. To say that this bill has First Amendment limitations is the understatement of this session.
Okay.
It's whatever the laudable intent is here, it's a bad bill that has Herculean constitutional problems.
Mr. Chair.
Yeah,
Mr.
Senator
Chairman, I have a
Peterson.
motion.
Senator Peterson.
I would just simply say Michelangelo's David would be in violation of this.
Yeah.
If you were to take a
right.
photo of Michelangelo, any Roman or Greek classical statue, you'd be in violation of the statute.
Yeah, Senator Norman.
I move to PBI the bill.
Is there a second? It's been moved and seconded to pass the bill by indefinitely. All in favor of the motion? Yeah, go ahead. Somebody want to speak?
Mr. Chair,
Go ahead.
Mr. Chair, the First Amendment issue, I have been told by counsel that being obscene, it takes away that issue. Also, the consent issue, everybody's what ifs comes down to, well, what if this happened with a statue with art? What if that happened right now in person? It happens like we make it illegal in person. And I found earlier, one of the senators say on the floor, we have to try something, talking about a littering bill, said we have to try something, something's got to work. And to not address this issue is just, it's very, with someone with 3 daughters, and I've only heard men address this in the committee. It's very hard to, I don't feel like this is getting a fair hearing, and this is a huge problem. So all I can do is urge the committee to discuss and consider the bill.
Okay, maybe you can go back and take another look at it with some people to try to fix it if you can. Anyway, we've got a motion before us to pass the bill by indefinitely. All in favor of the motion, vote aye. All opposed, no. Pass the bill by indefinitely.
Ayes 8, noes 5, 1 abstention.
8 to 5, the bill is passed by indefinitely. I think the bill has got possibilities that could be worked on, I think. Anyway, thank you very much. There's always next year. 8 to 5 to pass the bill by indefinitely. 8, 5, and 1 to PBI the bill. Okay, thank you very much and appreciate your efforts. Moving on to, now Delegate Levine, House Bill 2295. We've reconsidered your bill, and I believe there is a amendment. Is that the one?
Mr. Chairman, 2295 is the one that was similar to Senator Evans' bill about carrying a firearm on Capitol grounds. We haven't gotten to the other one yet.
Let's go ahead and do that one. Now, is that the same as Senator Evans or not? Just similar? Should we conform it to Senator Evans?
Mr. Chairman?
Yeah, go ahead. Senator Serval.
I like Delegate Levine's version of it better, actually, but I don't know how Senator Evans feels about that.
Okay, what's the difference between?
I believe Delegate Levine's bill covers Bank Street and also, was it 9th Street there where it runs along the edge of Capitol Square, although it's clear that if you have a gun in your car and you're driving on 9th Street, it doesn't pick you up. But it does cover Bank Street, which right now we don't control because the city of Richmond has it. And so that's why I liked this version better. But maybe Charles can, if I missed anything, he can clarify.
Charles, explain it.
No, Mr. I think Senator Serval is correct in his explanation, and those are the major differences. Is that the bill does cover the boundary streets around Capitol Square, where Senator Evans' bill was limited to the square itself.
Mr. Chair.
Yeah, Delegate Peterson, Senator Peterson.
Sure. I remember I had a question from Evans' bill that I didn't pick up on, but what about either state-owned or state-leased properties, particularly when the state is, say, leasing a property as part of a larger privately owned building? How do we treat that situation?
Mr. Chairman, I'm here if you...
Yeah, go ahead, Senator Delegate Levine.
Thank you, Mr. Chairman. And to be clear, I'm more than happy to conform this to Senator Evans' bill, and I think we can easily work it out in conference. So I'm fine with that. But to answer Senator Peterson's question, it's state-owned buildings or offices. If it's an office, it's only the office part. So if you have like a executive office in one part of, say, a strip mall, it would only apply to that office, not to any other part of the building.
So follow-up question, Mr. President?
Yeah, Senator Peterson.
So parking lots are out. So let's say, for example, you have a concealed carry permit and you have your weapon in your glove compartment or locked in your trunk. If you're in a parking lot, you're not now in violation of state law.
We have an exception if your gun is locked in your car. However, if you're in a parking lot like the ones close to the Capitol, you can't be wandering around inside the parking lot with your gun out. It would have to remain locked in your vehicle.
Okay.
Okay, all right. You ready to vote? Is there a motion to report House Bill 2295?
There are no amendments from last week or anything?
Are there any amendments? I don't think so. Are there?
Well, we were going to work it out in conference. There actually is one technical amendment that I wanted to add if we want to do that right now.
Yeah, go ahead.
Sure. I wasn't expecting that, so if you'll give me half a second, I'll bring it up. The Department of Corrections requested that we make one amendment in section I'm sorry, in section E.
Okay.
They don't want in section E where it says any employee of a state correctional facility or state juvenile correctional facility, they want to change that to any employee of the Department of Corrections.
Okay.
Or state juvenile
There
corrections.
motion, Senator Sasslaw makes the motion, Senator Dees seconds it. All in favor of the motion, say, the amendment, say aye. Aye. All opposed, no. The motion carries. Okay, is there a motion to report the bill as amended, and you can work it out later in conference? Is there a motion? Senator, it's been moved and seconded that the bill, House Bill 2295, as amended, be reported. All in favor vote aye. All opposed, no.
Ayes 9, noes 5.
Okay. So as 9, yes 9, nays 5. The bill is reported. Okay. Senator Delegate Levine, we have House Bill 1948 that we reconsidered, right?
Thank you, Mr. Chairman. That bill was my larger police reform bill. I recognize that some of the police things were not liked by the committee, so I have pared it down sharply. And now the only thing the bill does is adds to the prohibited category of bias profiling, which says the police can't do bias profiling on the basis of race or gender or disability. It includes sexual orientation and gender identity. That's all it does, is add those 4 words to the bias profiling. That's all it does as the substitute, which I'd ask, because it takes out all the police stuff that members of this committee did not like.
Okay, the bill only says in this, only thing it does is add sexual orientation and gender identity to the definitions of, it doesn't take anything
prohibited
out.
bias-based profiling.
Mr. Chair,
bias-based profiling adds those 2 concepts.
Mr.
Yes,
Chair.
Senator Deeds.
It's the same question Delegate Levine I asked the other day. How is a police officer, how's he supposed to know just by vision, just by what he sees, what a person's gender identity or sexual orientation is?
Mr. Chairman, I would answer the same way that things like race and gender and ethnicity are also not necessarily always clear. And that's why the definition says real or perceived. So if someone says, I'm going to get that pejorative trans person, or I'm going to get that, think of a pejorative word for someone who's gay, or I'm going to get that pejorative word for someone whose race you don't like. It doesn't matter whether the person is black or white, is gay or straight. If they perceive that someone is of this group and they act accordingly in bias, it's prohibited. And so it really doesn't matter what the actual race or ethnicity or sexual orientation of the person is. If the police officer expresses some anti-comment and then goes after them because of these characteristics.
So Mr. Chair, Delegate Levine, we're talking to prove an offense like this, you've got to be able to prove the officer said something. Is that contained in the bill?
So all the bill does is take the current definition that we already have of bias-based profiling. And all this is a definition of what bias-based profiling is. And what the code section says, and it was added in 2020, it says, for purposes of this chapter, unless the context requires a different meaning, bias-based profiling means actions of a law enforcement officer that are based solely on the real or perceived race, ethnicity, age, gender. It would add sexual orientation, gender identity, or any combination thereof, or other non-criminal characteristics of an individual, except when they're used to match a specific description. So this is actually just definitional. We already have it in our code, and basically we use it in other places of the code to say this is prohibited conduct. It's not a criminal activity, it's not a criminal offense. It's just a way to say, police, you cannot act against someone because of their race, you cannot act against someone because of their gender, and I'm adding you cannot act against someone because of their real or perceived sexual orientation or gender identity.
Okay, is there a motion to adopt the substitute, which is what this is?
Mr. Chairman?
Senator Sasslaw moves to adopt the substitute. Yes, John?
First, you have to reconsider the amendments that were adopted at the last meeting.
Did we adopt the amendments last time? Okay. Is there a motion to reconsider the amendments that were adopted last time? Senator Sasslaw moves to reconsider the amendments last time. Senator Deeds seconded. All in favor of the motion to reconsider the amendments that we adopted last time?
The hell is perceived sexual invasion? Senator Norman, did you wish to vote on reconsider? No. Ayes 13, no 0.
Okay, it's now been reconsidered, and there's a motion now to adopt an amendment in the nature of a substitute to House Bill 1948. Is there a motion?
Mr. Chairman.
Yeah, just a minute. Senator Sasslaw makes the motion. Senator Deeds.
Mr. Chairman.
Mr. Chairman. Just a minute.
If I'm voting on something, it's got to be released online to the public.
I know, that's what we're doing now, okay? The motion, that is to present the substitute, I guess. Go ahead, Senator McDougal.
Mr. Chairman,
go ahead.
I'm trying to pull it up on LIS.
Okay, yeah.
I see nothing.
Okay.
So it's not in the committee area, it's not in the public area.
Senate committee amendments, under the amendments.
Yeah, Mr. Chair, it should be available on LIS.
Yeah, make sure everybody has a copy of it.
Mr. Chairman, while we're pulling it up on him.
Yeah. Senator Norman.
Thank you, Mr. Chairman. If someone could, we're getting into a realm where there are no problems, I think, determining ethnicity, but can somebody explain to me what perceived sexual invasion is?
Sexual orientation, gender identity. Go ahead, Delegate Levine.
So just as someone can perceive a driver as African-American when they're not African-American and take actions that they would take against African-Americans, against that driver who doesn't have to be black at all, maybe they're Hispanic, someone could see...
Mr. Chairman, I don't care about ethnicity.
Okay.
I got it. My question was very narrow. What is perceived sexual invasion?
Sexual orientation is the word. And if two men are walking in the street arm in arm, one might perceive that they're gay.
It says sexual orientation or gender identity, those two words, those four words.
So someone, if they see two men kissing or two women kissing, one may perceive them to be gay.
Okay, everybody got the amendment in the nature of a substitute? It's been offered. Are you ready to vote? Does everybody have it? Does everybody have the amendment in the nature of a substitute? It's one line. Does anybody not have it? Okay. Senator Sasslaw moves to adopt the substitute. And
Mr. Chairman.
Second, yes, go ahead. Who's next?
Durville.
Cyril, go ahead.
I'm just trying to understand what the bill does now. Well, first of all, can the delegate tell us whether or not he intends to put this bill in conference if this passes?
No, I will simply pass. I will accept this amendment.
Mr. Chairman, second question.
Second question, go ahead.
I'm trying to understand what the bill now does. I think, I haven't pulled up the entire code yet, but I believe this is an amendment to the Community Policing Act, which was the bill Delegate Torian passed last year. Is that right?
That's correct. So if you look at 52.30.2, it says no state police officer shall engage in bias-based profiling in the performance of his official duties.
Mr. Chairman?
Yeah, Senator Searle.
Okay, so my understanding on that act is I don't believe, if maybe Delegate Levine or council could correct me, but I don't believe that act has any consequences to it except for the fact that localities are required to record different the race, ethnicity, age, gender, whatever, of the people they stop and have interactions with and produce reports of that. Is there some other consequence this creates besides enhancing the reporting requirements for local law enforcement agencies?
There's not, Mr. Chairman, Delegate, Senator Sorvo. In fact, it doesn't even require the reporting because I didn't change that part of the bill. It's simply a statement that it's illegal so that we can teach our state police that it is illegal, that it is against the code to do this, but there are no consequences for it.
Okay. All right, any other questions?
I got one question.
Yeah, Senator Morsi.
Delegate, if an officer engaged in bias-based profiling and as a result of that uncovered evidence, indicia of a crime, contraband, guns, etc., would that violation of the bias-based profiling prohibit that evidence from those items recovered from coming into evidence at a criminal trial?
Senator Marcy, that's a really good question. I guess we could ask counsel. If someone goes after someone because they're black and stops the car just because they're black and finds contraband, can that contraband be used in a trial? I don't know, but that's what the current law.
Mr. Chair.
Well, I can already tell you for 20 years, 30 years, we've decided and courts have ruled that if a police officer stops an individual only because of their race and then they do that, that is profiling and that evidence would be suppressed. But go ahead, Steve. Charles, do you want to address that? My question went a little bit deeper, but sure.
Mr.
Charles? Charles?
The only time that evidence can be suppressed is if it is, number one, a violation. Well, number one is if the General Assembly says that it cannot be admitted because of a particular violation, and that has to be expressed. Or if it's a violation of the Fourth Amendment and on balance, the deterrent value of suppressing overweighs the harm of suppressing otherwise reliable evidence.
A follow-up question, Mr. Chair.
Senator Morsi, go ahead.
Steve, you remember a number of years ago, cars coming up from Florida with Z license plates, which indicated a rental vehicle, and the individual was African-American, and they were stopped on a rental car coming up from Florida, and they were black, and they recovered, cocaine in that car. Defense attorneys would challenge it based on a violation of the Fourth, an unreasonable search and seizure, which was the nexus, which was based upon that profiling, that racial profiling. And if the judge ruled, yes, it was racial profiling, the evidence didn't come in. Isn't this an extension of that? Isn't this legislation an extension of that?
Steve? Steve?
I don't recall cases being suppressed because of a successful racial profiling argument. Because in any instance, the question is whether the officer had an objective reason to believe that a crime or a traffic infraction was being committed. The problem, Mr. Chairman, as Senator Morrissey points out, is that we in the criminal justice community have always known that narcotics officers in plain cars don't stop for tag violations or driving 59 miles an hour in a 55. They stop because of what Senator Morrissey refers to as racial profiling. The General Assembly has addressed this with legislation that was enacted in the last special session, providing that evidence discovered as a result of equipment violations or the odor of marijuana is not admissible. So the problem is real. I don't know that this bill has anything.
Mr. Chair.
Just let's see Steve finish up. Go ahead.
I don't think it's relevant to the bill.
Well, let him finish. Steve?
I'm finished.
Go ahead, okay. Yeah,
Mr.
Peterson,
Chair.
yes.
This bill, or the original statute, was to address an issue of racial profiling, specifically the issue of driving while black, okay? And that was an issue that we knew we had. I'm not aware of an issue of driving while gay. I'm really not. And I'm not being facetious. I'm not being facetious.
Go ahead, okay.
We're talking about people that were pulled over based upon characteristics that were observable from a distance. This is a different issue, and I realize Delegate Levine's fighting hard to save his bill. I appreciate that, but we're diluting what is an issue, what is a material issue, with what frankly is not a material issue. And I think this bill's a bridge too far, and I would move to PBI.
May I respond, Mr.
Just a
Chairman?
minute, Delegate Levine, finish up. Go ahead.
Thank you, Mr. Chairman. This profiling against gay and trans people has been going on for hundreds of years. The Stonewall Rebellion in 1969 happened because Black transgender people were being persecuted and prosecuted by police merely for being trans. That's how a whole movement began. Some 20% of transgender people are stopped. And I'll tell you why they're stopped, particularly transgender people of color. The police harass them, and then they look in their purse. And if they find a condom, they're charged with being sex workers. This is a tremendous problem. And I'd be happy to give all kinds of studies, peer-reviewed studies, that frankly, more often than Black people are profiled, Black transgender people are the highest profiled people in the United States of America. 20% have been stopped by police for no crime whatsoever. This is a tremendous problem.
Is there ready for a motion? I think we're ready for a motion. I think everybody understands it. I didn't hear. Is there a motion? The motion, okay, to pass the bill by indefinitely. Senator Peake and Senator Peterson, is that right? Peterson and Senator Peake. Listen, use your microphone so I can actually hear you. All right, Senator Peterson moves to pass the bill by indefinitely. Senator Peake seconds the motion. All right, are you ready to vote? Yes. All in favor of the motion to pass the bill by indefinitely. Vote aye if you like it, or again, no if you don't. If you disagree.
Ayes 7, no 6.
7 to 6 and 0. 7, 6, and 0. So the bill is being passed by indefinitely by vote of 7 to 6. Okay? All right. Okay. Okay. Thank you, Delegate Levine. Appreciate your efforts. Now, Delegate Ferris has a 2298 muzzle loading rifle and shotgun definitions. Okay, Delegate Ferris, are you there? Is he there? Yes. Okay, Delegate Ferris.
Yes, I'm here.
Yeah,
So,
go ahead. Okay, tell us about your bill, about muzzle loading the rifles.
this is a bill about muzzle-loader rifles. It's there's a new rifle that has come out that you can put the propellant and the charge in from the breech end, and you can take it out from the breech end. However, the projectile still goes in from the muzzle end. If you do not discharge your muzzle loader after you finished hunting, it is it's pretty hot. We call it hot. It can discharge. Any other kind of gun, you can unload them, but with the muzzle loader, you have to discharge it or fire it to unload it. This is really a safety precaution, and you can also take your powder out and keep your powder dry.
Okay.
So
why do you want the bill? What difference does it make?
So we just changed the wording in the code to say the propellant and the propellant can be put in from the breech end. However, the projectile is still loaded from the muzzle end, which that's what classifies it as a muzzle loader. The current code says everything comes in from the muzzle end.
What difference does it make? I mean, what's the real world difference?
Because there is a new gun that the propellant can be put in from the breech end, and the projectile goes in from the muzzle end.
Mr. Chairman, question from patron.
Yeah, Delegate Senator
Sturville. Delegate Ferris, I think we get that part. We're just trying to understand what difference it makes. I mean, legally, why does it matter if these words are deleted from the code? What's the practical effect?
It describes this type of it allows for this type of gun to still be considered a muzzle loader.
Mr. Chairman.
Because
okay.
Further question?
Yeah, Senator Sturville.
some of us don't have guns. We don't understand what difference it makes to be a muzzleloader, like in terms of the law.
Mr. Chairman,
Yeah,
it makes a difference about
McDougal,
when you
Senator
can hunt.
McDougal. Senator McDougal.
Makes a difference about when you can hunt. The
When you
season
can-
starts with bow, which could
Chair.
be
Okay, just a
cross
minute.
or regular, and then it goes muzzleloader, and then it goes gun season. So
Okay, Senator
it's a
Deeds.
group of people that can hunt,
Delegate
still hunt
Ferris,
earlier.
Would you agree with me that when the muzzleloading seasons started many years ago, we were looking at using primitive weapons, and the weapons have gotten less primitive about it with every change in mechanization, and now while we're still muzzleloading, the weapons are pretty much as powerful and as accurate as modern weapons. And this one takes them this takes it a little bit further.
Well, to some point, that's true, but not completely. And this really is a safer type of muzzle loader, and it's something that we're seeing people have started purchasing that are older, and that the Department of Game and Inland Fisheries, of course, this is the first year they've sold more hunting licenses than the previous year. And so it just gives somebody another opportunity to get in the woods and hunt safely and enjoy their time.
Delegate Ferris, do you have anybody to want to speak for the bill? Just is there anybody who want to speak for the bill, or anybody who want to speak against the bill?
Yes, Mr. Chair, we have 2 for the bill, I believe.
All right, 2 for the bill, very briefly.
Philip Van Cleve, go ahead.
Go ahead, Phil.
Yes, let me say that part of it is indeed safety. That if there are embers in the barrel from a previous shot and you pour gunpowder down there, you will indeed could set off the charge. This is a much safer mechanism. While it still requires the long step of loading the bullet in from the muzzle. So it's much like a regular muzzle loader, but a lot safer technology.
Patricia Webb, please go ahead.
To expand on what Mr. Van Cleve said, again, the issue is safety. This would not make the guns, the gun is still a single shot that's loaded 1 shot at a time from the muzzle. But when you have a muzzle loader and you load it and you go out hunting and then you don't see any game and you don't shoot it, if you don't have this option, then your only way to unload that muzzle loader is to shoot it or to use a tool that actually screws into the projectile and pull it out from the muzzle end, and that may or may not work. So this reduces the risk of double charging a gun and causing injury to the hunter. It reduces having to take a shot for no reason when you didn't find any game, and it just makes the overall process safer.
Okay,
it does not make the guns more modern in the respect that Senator Deeds was saying.
Thank you. Is anybody against this bill? It's a safety bill. That's what I'm hearing. Anybody against the bill?
Lori Haas, please go ahead.
Just a minute. Go ahead, Laurie.
Good evening, Mr. Chairman, members of the committee. This is Lori Haas with the Coalition to Stop Gun Violence. We don't really have a position on the bill versus, the language to make these weapons more useful to hunters, as the patron has mentioned. We would just like to point out that muzzle loaders are exempt from the background check as under the definition of antiques, and I believe that Charles or someone with more knowledge of the list of types of firearms that are exempt from background checks could check behind me on this. Okay. But we believe with these changes to this type of weapon, that these types of
report. Just a minute. Go ahead. We're not finished. Laurie's talking. Go ahead, Laurie. We'll listen to you.
Thank you, Senator Edwards. We just believe that these weapons should now be included in the list of firearms that do require a background check. They should not be exempt like other antiques. Thank you.
Okay. If anybody else want to say anything, I think we've heard it all.
Andrew Goddard.
Very briefly, 15 seconds. Go ahead, Andrew. Go ahead.
Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety. We have no problem with these guns being used for hunting. However, especially since they are a lot safer. However, they cannot be considered to be antique firearms under the section of 182308.2:2. So therefore, they have to be sold with a background check. Thank you.
All right, thank you. Is there, no, I think we've finished the public comment. Is there anybody else have anything to say? Is there a motion? Senator Sasslaw moves to report the bill. Is Senator Obenshain seconds the motion? All in favor of reporting House Bill 2298, say, vote aye. All opposed, no.
Ayes 15, no zero.
Ayes 15, no zero. The bill is reported. Okay. Now
Thank you, Mr. Chairman. I've been listening to the
thank you,
earlier
thank-
committee this week and today. I've enjoyed it.
Yeah, thank you. All right, House Bill 2317, Robinson, Advisory Committee on Sexual and Domestic Violence. Membership duties increased from 15 to 19. The total number of members of the Advisory Committee on Sexual and Domestic Violence. Is there anything more than that?
No, sir, it is not.
All right, Senator Sasslaw moves to report the bill. Senator McClellan seconds it. All in favor of reporting House Bill 2317, vote aye. All opposed, vote no.
Ayes 15, no zero.
Ayes 15, no zero. We have one more bill, I think, and that's.
Thank you.
Thank you. HJR.
Mr. Chairman,
Yes.
Mr. Chairman,
Chair,
you have 3 more bills.
Okay, well, let's do HJR 629, delegate hearings, the appointment of chairman of the Virginia Criminal Sentencing Commission. It confirms the appointment by the Chief Justice of the Supreme Court of Virginia of the Honorable Edward L. Hogshire as chairman of the Virginia Criminal Sentencing Commission. He's a very good friend of mine, a classmate in law school. He's a great guy. Okay, it's been moved and seconded that that HJR 629 be reported, and the chairman and the General Assembly confirms his appointment. All in favor of the motion, say aye. All opposed, no. Motion carries. All right, 15-0. Okay, this is 15 to nothing. Okay.
Mr. Chairman.
20, what is it, 23-18?
Mr. Chairman.
Yes, Senator Obenshain.
Delegate Mullen, I know, is on the line. This is a cognate of a bill of mine that was actually, and I hope this doesn't derail it, but it went through rehab, but the House has passed Delegate Mullen's version. They've acted on mine and have conformed mine to his. I agree with his version. But I know that Delegate Mullen actually has something that he would like to say, and if you would give him just a second to say it, I know he would be grateful, and I would too.
Okay, is this House Bill 2018? Is that right?
That's correct.
2018. Yeah, Delegate Mullen.
Thank you, Mr. Chair. Mr. Chair, I just wanted to say that only a few months ago, I was speaking with our own friend, Senator Chafin. I know how much that this bill and the work to be able to protect those who are elderly in our community, who are under financial exploitation, has been so important to him. I know that this was part of his legacy. I know we all miss him greatly. And the fact that I can carry on and help at least one small part of the bills that he cared about, I know that's very important to me. I know it's very important to Senator Obenshain. We miss him greatly. This is a cognate, so it's, I think we don't even need to go to conference, but.
Second.
Okay, now no amendments, right? It's House Bill 2018 has been moved and seconded that House Bill 2018 be reported. All in favor vote aye, all opposed vote no.
Ayes 15, no zero.
15-0. The bill is reported. Are there any other bills? Am I missing something?
Mr. Chairman.
Yes, Mr. Chair.
Okay, go ahead.
2038, Delegate Scott's bill.
Okay, 2038, Delegate Scott, probation, revocation, suspension of sentence limitations. Okay, Delegate Scott, is this the last one?
Thank you. Yes. Well, I don't know, Mr. Chair. Thank you, Mr. Chair. This is my last one. Hopefully. Thank you, Mr. Chair, members of the committee. This is a probation reform bill. We had, I can safely quote, I talked to the backup spokesman tonight, Nate Green, and he told me that I can report peace in the valley. We did a lot of work on both sides, had some bipartisan support. What the bill does is it limits the amount of time that folks can be on active supervision to 5 years, and then beyond that, they'd be on good behavior, except for the statutes that are lined out in 19.2-306, I believe, which is sex crimes and other violent felonies, which they would still be on supervised probation for the length of the time. It caps, the bill articulates what a technical violation is, which is already articulated in documents that the probation officers have each member sign. And if it's a technical violation that doesn't involve a gun or some other assault or violence or absconding, then it's treated as a technical violation. If it's one of the other more serious absconding or something with a sexual offense or something, then it's treated as a second violation where they would get jail time as a first technical violation, no jail time. It's a lot of information. I can give you 60,000 people on probation in the state of Virginia, 6,000 in DOC for having committed no new criminal offense, but just technical violations. Okay. And I would hope that the members, and I have 3 people at least here to speak, and I hope that you can get them a moment to speak.
Anybody against the bill? Anybody to speak against the bill? Okay,
the bill be reported, Mr. Chairman.
Very briefly, have each of the 3 people very briefly say who they are.
Mr. Chair, we actually do have one person who wishes to speak against the bill, I believe.
Okay, 3 for the bill, just very quickly.
Eileen Longenecker, please go ahead.
Yes, Mr. Chairman, thank you. Eileen Longenecker on behalf of OES at the Supreme Court, speaking in opposition to House Bill 2038, primarily with respect to the new statute 19.2-306.1, which limits how judges can handle technical probation violations. The judges who reviewed the bill expressed several concerns about the bill. They indicated that they often don't receive probation violation letters before from probation officers until there have been several violations. And they actually think that this legislation could result in the court receiving a probation violation letter for the first violation, which actually would result in more people being incarcerated on probation violations than are currently. They also noted that they receive guidelines currently for probation violations, which assist the judge in determining the appropriate consequence for a probation violation. They also expressed concerns about being restricted in what they can order, which for essentially a violation of their court's order, which they feel is very different from the General Assembly setting the maximum sentence or the sentencing range for a criminal offense. And their concern is that what's being restricted is an essentially judicial function, inherently judicial function. Lastly, they indicated that dealing with probation violations is very individualized, and they believe one of the arguments that is used for eliminating mandatory minimums, that punishment should be left to the discretion of the judge with respect to the specific case and the specific person before the court, that same argument should also apply to probation violations, and that is their concern with the new statute. Thank you.
Thank you. Is anybody else against the bill? Is anybody who wants to speak in favor, very briefly?
Eugene Oliver, please go ahead.
Yeah.
Thank you, Mr. Chair. My name is Eugene Oliver. I'm the president of the Virginia Association of Criminal Defense Lawyers. We strongly support this bill. A large part of my own personal practice involves probation violations. This is something that I've seen people get years for technical violations. So certainly I think this is an area of the law that needs major reform. I appreciate all the work that Delegate Scott has put into it, and I strongly urge your committee to pass this bill and report it.
Can
Thank
I ask
you.
a question of this witness?
Go ahead.
Mr. Oliver, my question is, if a judge knows he can only give 5 years of supervised probation, you heard what the lady from the Supreme Court said. Do you think this is going to result in a longer upfront period of incarceration for the defendant, or a quicker draw on the first probation violation and more incarceration?
Senator Dees, let me take that kind of one part first. With regards to the length of suspended sentences, I would say the overwhelming majority of these are done via plea agreement, so I don't anticipate that that's necessarily going to change. Certainly it may if judges are looking that far ahead, but I know most judges will look at the immediacy of what they're doing. With regards to the nature of the technical violations, certainly that's a concern, but having practiced in multiple areas of the state, I will tell you, probation officers across the state have different policies. I've seen some probation officers where they violate on the first technical violation, and others where they will only violate you if you pick up new charges. So certainly I think there may be some changes, but I don't think it's going to be something that we're going to see statewide.
Okay, I understand that Charles has an amendment to Delegate Scott's bill on 2038. Charles, do you have an amendment?
Mr. Chair, Steve and I are working on language. I'm not sure we quite have it down right now, but the issue that we're addressing, just to be very brief, is on lines, I'll say 99 to 108, the language is drawn to where the court can suspend the imposition of a sentence. That is I'll say an older practice where the court suspends the imposition of the sentence. The more current practice is the court suspends the execution of the sentence. We need to come up with some language to address that, because the bill as it's drawn doesn't reflect what happens if the court suspends the execution of the sentence, only the imposition of the sentence. Steve has shared some language with Delegate Scott that I think is agreeable to, but Steve and I are still basically figuring out if that's the best language. We will definitely have language to have it by the floor. If the committee was to act favorably in the bill and likes the concept of the bill, we can definitely pick it up, but that's why we don't have the amendment right now. I think Steve would agree with that.
Okay.
Well,
Steve,
we have language, Mr. Chairman, that we can offer now. Charles and I, because we've been drafting during this afternoon and during this meeting, as always, have concerns whether we have gotten it right. But I can give you language right now that is as good as we can get it at this hour.
Why don't you give us something now and then maybe improve upon it by the time it goes to the floor.
All right, here you go. At line 99, subsection C will be rewritten as follows, to read as follows. If the court, after hearing, finds good cause to believe that the defendant has violated the terms of suspension, then the court may revoke the suspension and impose a sentence in accordance with the provisions of 19.2-306.1. What that amendment does is strike the current first sentence in subsection C and rewrite it as I've just read it, and then the remainder of subsection C would remain as it is. The only other amendment that we drafted would be at line 131, subsection B, that it begins at line 131, would read as follows. If the court finds the basis of a violation of the terms and conditions of a suspended sentence or probation is that the defendant was convicted of a criminal offense that was committed after the date of the suspension, or has violated another condition other than a technical violation or a good conduct violation that did not result in a criminal conviction, then the court may revoke the suspension and impose or resuspend any or all of that period previously suspended.
Okay.
Hey, Mr. Chair, Mr. Benjamin did send me that language a few times. We've gone back and forth, and I would be amenable to that amendment if it's the committee's will.
Mr. Chair.
Yeah, Senator Morrissey.
I followed those amendments pretty closely, and I'm going to make a motion that we adopt those amendments.
Okay, so second by Senator Lucas. All in favor of those amendments, say aye. Aye. All opposed, no. The motion carries. The amendments are adopted. And then when we get to the floor.
Move to report as amended, and understanding that we might have more amendments.
Okay. Senator Dees moves to report the bill as amended. And Senator Lucas seconds the motion. All in favor of the motion to adopt the bill as amended, vote aye. All opposed, no.
Ayes 9, no 6.
Ayes 9, no 6. The bill is reported as amended.
Thank you, Mr. Chair.
Okay, I think, are we finished? If so.
Yes, Mr. Chairman, that's it.
Yeah, Kristen, go ahead.
No, we're all finished with our docket, Mr. Chairman, and the bills in committee.
Okay, well, I want to thank staff. John Bennett here has been fantastic as clerk. Steve Benjamin, our counsel, thanks so much. Kristen Walsh, Charles Quigliotto. Everybody stand up and give them a round of applause. Y'all have been the best, absolutely the best. Thank you all so very, very much. So with nothing further, if not, the committee will rise and we'll